Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. For the members with microphones, another reminder, if you want to talk, just press the microphone button until it turns green. Otherwise, we won't hear you, and the folks on our Zoom conference also won't hear you. Under the Bagley-Keene Open Meeting Act, remote members of the committee must be visible on camera unless such appearance would be technologically impracticable. If so, the member shall announce the reasons for their non-appearance during the roll call. Remote members must also disclose any individuals aged 18 years or older in the room with them. Karen, can you please take the roll?
Ali not present. Brown?
Present.
Cassidy? Shivers?
Here.
Coleman? Coleman not present. Guzman? Oh,
We can't hear her.
oh. Coleman is present.
Coleman is present here.
Guzman? Guzman not present. Joyce?
Oh, geez.
Present.
Mad Watkins?
Present.
Mercado? Is she here? Mercado not present. Mohebi? Mohebi not present. O'Reilly?
Present.
Perlman? Poindexter? Not present. Riley?
Present.
Next on the agenda is the call for public comment. Before we begin public comment, I'd like to remind everyone that, also under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on our agenda or be related to matters that are within the jurisdiction of this agency. Specifically, COPRAC's work includes drafting advisory opinions on issues of professional ethics based on questions submitted to the committee or developed by the committee on its own initiative. We also draft fee arbitration advisories providing guidance to fee arbitrators, administering attorney-client fee disputes. We conduct studies and provide advice to the board on professional responsibility. We also study and recommend changes to the rules of professional conduct. The committee sponsors educational and outreach programs. COPRAC does not have authority over attorney discipline matters. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. We have elected to defer some public comment on agenda item number 1 until that point. Karen.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and State Bar staff will call on you in the order that hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. I'll go in the order that the raised hands are received.
Yes, good morning. Can you hear me?
Yes, we can. You have 30 minutes. 3 minutes. So sorry.
I'll take it. I'll take the 30. Thank you. My name is Henry. I've called into different meetings and of the State Bar, specifically addressing the very topic of today, which is attorney professional conduct and ethics. And one of the things that this body can do is advise the board to take into consideration which different backgrounds should in fact not only be come under heavy scrutiny, but also be considered for no longer being admitted to the California State Bar. And such questions, I think, should mirror not only for US law, but also international law. And I want to give a very specific example. Several countries, including Germany, an ally of the United States, have outright outlawed criminal enterprises like Scientology from being completely barred from holding any sort of government-related or adjacent positions because they have, rightly so, been denominated as a sect and a criminal enterprise. And that is something that the California State Bar needs to pose as a question to the Board of Trustees to take into consideration. Current members who are licensed and directly do litigation for the criminal racket Scientology need to be considered and poses a question of whether they should be allowed to continue holding a license as a lawyer and representing people and doing any sort of litigation as such for Scientology. At this point, there's far more than definitive proof. We have collusion under the Bain Act and deprivation of rights under Title 42, left, right, front, and center. We have them conspiring with city attorneys to politically and vindictively prosecute anybody that dares criticize their political allies, and it needs to stop. Okay, it needs to stop. This body has the authority to, at the very least, pose that as a question, as an agenda item, and take it up for consideration as to whether that should be as a item that the board considers for a review. The board has that authority to do so, and rightly so should mirror what the international community is doing with such criminal enterprises. The United Nations does that with various other criminal enterprises and various other acts of war and crime, just like they did recently with their declaration on genocide. So why can't the State Bar do
We have
their
30 seconds
part?
remaining.
Why can't the State Bar do their part as well in making sure that such criminals do not have the power or opportunity to be in such a position? Kendrick Moxon is one of those lawyers that absolutely needs to be reviewed, and there's many other Scientology affiliated lawyers that need to absolutely be permanently disbarred, at the very least from the State Bar of California, from practicing law. And so that's what I hope this board does. That's my petition to the board, and I thank you for your time.
Thank you for your public comment. Next is Inri. You have 3 minutes to talk. Oh, I'm so sorry. And next is Mr. Kai. You have 3 minutes to talk.
Good morning. Can you hear me?
Yes, we can hear you. You have
Okay.
3
Okay. Good morning, all members. My name is Kai On from Sacramento. Last meeting, I talked about my complaints against Attorney General and Sacramento District Attorney. They did not investigate Sacramento DA office, and SPD provide me fake information about my father's death. I report the incidents to Mr. Robert Bonter and Mr. Tien Ho's agents back in January 2024. After the last meeting, State Bar closed my complaint without reviewing DA case 99F08735 to confirm my father, Woon Kong On, was the victim in the case, and Mr. Jung So Fong was sentenced for hit and run that killed my father. Also, the letter from State Bar has no name, no title, and no signature. I cannot verify if my complaints were closed by authorized State Bar staff. State Bar is helping to cover up a Sacramento law enforcement scandal. On September 22nd, I emailed a letter to Board of Trustees and Committee on Professional Responsibility and Conduct requesting an internal investigation inside State Bar. The letter has the detail and evidence. However, I have not heard anything from State Bar. All committee members, how you can serve State Bar that has misconduct issue. I have talked with this committee since March. Chair Ms. O'Reilly, could you please provide comment on this incident?
Thank you for your public comment. Next is Laura. You have 3 minutes to talk.
Hi, can you hear me?
Yes, we can. Go ahead, start your 3 minutes.
Okay, thank you. My name is Laura Anderson. I was a born and raised child member, slave, I would say, indentured slave, signed a billion-year contract in Scientology's. I knew Kendrick Moxon and still do to this day. Kendrick Moxon is a lawyer for Scientology. We have sent you guys a report on his behavior over the last 30 years that I'm aware of his illegal tactics and fraudulent falsifying paperwork and everything to the FBI. The Lisa McPherson report, I've sent this all to you guys in a report against him and against his license, and it needs to be looked into. 3 days ago, I was let go from my job because I'm protesting Scientology. I was let go from my job because part of Moxon and OSA's tactics, the internal organization of Scientology, is to blackmail and dead agent people who are exposing the crimes and the illegal tactics like Kendrick Moxon does with his license. And so what they did is they sent all this fake blackmailing and twisted photos of my no, I'm a rock star. I make music and create a beautiful life now. And I never had that in the cult of Scientology. And because I have all this information and because I've lost my family and everybody, and I'm exposing Kendrick Moxon, the lawyer of Scientology, who has been getting away with even his own daughter's death. He lied and falsified records because she unalived herself. She unalived herself because she was trapped in the cult of Scientology. So Kendrick Moxon's license, please, he keeps using this to attack people. I've lost my job 3 days ago, okay? I was on the Lisa McPherson case when Kendrick Moxon was lying about documents on the Lisa McPherson death case. I was literally shredding documents as an underage minor working for Kendrick Moxon. He needs to be investigated. His license is literally ruining people's family lives today, to this minute that we speak. This is what he's doing with his license. And because he keeps getting exposed, it's getting worse and worse. His behavior is getting worse and worse. And nobody on the bar is taking any responsibility to do something about this. Do you hear me? Please, please. I don't know how much else more I can say. Kendrick Moxon is really abusing his law license. Please revoke his license. Please put him in court let him describe why he does these illegal tactics. Let him explain to himself, to you, to the board, why this is fucking okay. It's unbelievable. It's not okay.
Your time is up. Please wrap it up. Thank you for your public comment. Next is Audit LA. You have 3 minutes to talk.
I'm also here to Kendrick Moxon. I've never been in this, but I'm a fierce advocate. First and foremost, the person you just heard, who there's not enough time to tell you everything, and since I'm advocating for the victims of Scientology, those who left and those who are still trapped, I have been fair gamed as well. Okay, I am being followed. I'm being followed. Been having they come to my neighbors, come to my kids, and they, just different family members. He is trying to demean me, and he's spreading all kinds of absolute provable lies to defame to all the state departments and to anywhere where I serve, trying to do it, trying to get me removed from things, trying to get me to be taken seriously. I have proof, and I've submitted so much proof as in form of complaint, also proof that he's lying to the city about this, that they think they act on being no parking. Okay, I have proven that, I have sent so much evidence, and yet they keep saying my complaint it's not quite enough. Well, what does it have to be that that I prove that he killed somebody? I mean, you're not allowed to lie to city entities. I've sent evidence that what he's saying about me is a lie. I sent evidence that it's a lie about the parking, saying that there's no parking to the city when when it's not true. What point was these, open investigations? And I know for decades they've been trying to supply you information. He was one of the unindicted co-conspirators in of U.S. government. And okay, he wasn't indicted, but why is he allowed to practice law? There's so many other cases that he's been involved in and misdeeds. Wallersheim case, Wallersheim versus Scientology, and there's other Lisa McPherson case, different cases, and you guys just keep ignoring it. I don't know who he knows or who I don't know what the influence is, but you guys, it's not going away, and he needs to be investigated and put before whatever tribunal. He needs to be, held liable for all he does. There's too many people that are coming forward that he's absolutely trying to ruin everyone that speaks up against Scientology. He's taking it personally, whatever, and he has no right to do that. I'm speaking up for victims. I'm speaking up for the things that they do wrong with the city. And, so I'm allowed to be an activist and an advocate, and he has no right to just try to destroy my life because I'm speaking up for victims. Please make it stop. Thank you. Okay, guys. Sorry.
Up next is Benjamin. Benjamin, you have 3 minutes to talk. Benjamin, yeah.
Thank you. Can you hear me?
Yes, we can.
Thank you. I'm a deputy district attorney in Placer County, and I handle asset forfeiture cases. And I'm doing public comment today to talk about the proposed rule saying that asset forfeiture money should be treated like trust accounting and be required to do the same reporting. It's my understanding that Monterey County District Attorney's Office sent a letter with similar comments, and we concur with that letter. And I wanted to make our own public comment today. Our office wants to make sure the bar understands we believe that there is an existential difference between client funds and asset forfeiture funds, and requiring our office and similar offices to report these asset forfeiture funds as client funds is unnecessary and would be take significant resources on our part. There's already significant oversight over asset forfeiture funds. The county auditor controller monitors how these funds get deposited and how we ultimately are able to distribute them and spend them. There's also annual reporting required to the Department of Justice. And there's actually a conflict between the Health and Safety Code and the client funds requirement of what would happen to interest on these funds. We could not put these funds into the IOLTA type account because it's our understanding that the interest from that account would go to the state bar, where the Health and Safety Code requires the money that is asset forfeiture funds pending resolution of the asset forfeiture case. That interest must be held in that account to be returned to the person from whom the money was seized, if that happens, or be distributed per statute. The money must be distributed per statute. Health and Safety Code 11370 at SEC has very specific requirements of what happens to this money. It's existentially different from client funds because we don't have clients. Our client is the people of the state of California, not the individual people from whom the money might be seized. There's no attorney-client relationship between us and the people from whom the money is seized. And there's no danger of commingling because we don't actually have any funds that could be commingled with these funds. There's no need for reconciliation or retention of canceled checks because there is no such, that doesn't happen with these. There's no possibility of a negative balance. There's no running balance. There's no.
Your time is up. Please wrap it up.
Thank you very much. We think that the committee should not consider asset forfeiture funds to be client funds and require the same accounting. Thank you so much.
Thank you for your public comment. Next is Merjam. Merjam, you have 3 minutes to talk.
Hi, can you hear me?
Yes, I can hear you.
Okay, great. I'm also calling regarding Kendrick Moxon. I already spoke about the same topic last month when I was still unaware of the fact that the California bar member Kendrick Moxon has sent a letter where, among other people, he is also stating slanderous statements and defaming me to the city officials. What type of a lawyer is doing this? I really urge you to investigate on him before you're going to have a legal case also on your hands, because this has been now reported to you numerous times. That's all.
Thank you for your public comment. Next is Jill. Jill, you have 3 minutes to talk.
I'm going to continue my information to give to you on Kendrick Moxon. He fabricates lies against the Scientology's critics. He makes things up. He puts people in court with use of lawfare. He files restraining orders with no basis against people and puts people up to setting up people that are protesting the abuses within the building of Scientology in Los Angeles. You've got to do something because it's dangerous to make things up, to ruin people's lives that are trying to call attention to the abuse, the trafficking, the labor law violations within those walls. He lies. He's fabricated evidence in court with one case. He totally edited a video to make it look wrong. It's wrong. What do you guys are just sitting on your hands doing nothing about this person that needs to stop. Even his associate is team member at his office in Burbank on 3500 West Olive Avenue. His associate, Jean Morrison Sue Reynolds, is not allowed to practice at all because she's not compliant with her education. Maybe you need to check in to see if he's compliant with his continuing education. Maybe he needs a course on not doing this to people and being ethical and not lying and making up cases, filing vexatious lawsuits against people that are criticizing the abuses that are well known. That's well known on the internet. All you have to do is look up what's going on with the case that's pending now with human trafficking against its leader that he's propping up and helping cover for. Something is wrong here. It's unbelievable. I don't know what else to say, but it's just bizarre that when you look up a license number, he's still allowed to practice. They don't allow healthcare people to practice medicine or nursing if they're making up lies on charts and falsifying information. Why don't we have the same laws and standards for this attorney that shouldn't be an attorney? I consider him a fake Timu attorney. Bye.
Thank you for your public comment. Up next is Gigi. Gigi, you have 3 minutes.
Yeah, so I would like to speak about Kendrick Moxon as well. I know that everyone, Scientology deserves to have a lawyer represent them. And I know zealous representation, diligent, whatever, but that has to be within the bounds of the law. It has to be legal stuff that they're doing for their client. And there's been a history of Kendrick Maxon doing stuff that is illegal. As people mentioned, look up Operation Snow White. There's a really good Wikipedia page about that. Also in 2013, he was involved when David Miscavige, the leader of Scientology, his dad was followed by someone and Kendrick Maxon was paying him. It's documented. Like Laura, she spoke earlier. She used to work for him when she was in the cult. She had to shred papers, as she was saying. It was hard to hear because her phone kept cutting out. But I know her story. She was working right there, shredding papers, important papers, as she didn't know what was going on because she was born and raised there. But he knew what was going on, and he was orchestrating people shredding papers for Lisa McPherson, which that's an interesting case to look into as well. But now he's going after people that are using their First Amendment rights, protesting, using legal warfare, putting ROs against people. He's doing these packets are going out where it's saying that he's telling city officials that people are in a hate group just because they disagree with the abuses and atrocities that are going on in Scientology. Everyone that I've heard that is protesting right now, they're doing it for the abuses and the atrocities. They aren't necessarily saying, you know, that Scientology is, I mean, they call it a cult, but they're not saying that Scientology alone is the reason. It's what they're doing with the abuses, whether they're infiltrating the government and colluding and doing shady stuff that way, or whether they have Kendrick Maxon doing this legal warfare with all these ROs and charges that he's pushing the DA to give and all this stuff that he shouldn't even be doing. He shouldn't have his license after Operation Snow White. What is taking so long for someone to actually look into his whole history? He has a really, really bad documented public history. Please look into Kendrick Maxon. And if you can't get rid of his license, do some type of punishment for it because he is not being ethically correct. He is using legal warfare. Thank you. I yield my time.
Thank you for your public comment. Do we have any in-person public comments? Please raise your hand. There are no more public comments.
We have a couple of public comments that are just deferred to the first agenda item. Let me also say again, this committee, COPRAC, does not have authority over attorney discipline matters. Public comments that relate to attorney discipline matters should be directed to the state bar agency that has jurisdiction over those matters. Okay, let's move on to the approval of the minutes from the last meeting. Are there any corrections or modifications to the open session minutes? May I have a motion to approve the minutes from last September 12th? Vikita?
I'll second it.
Carrie seconds. Okay, Karen, can you call the roll?
Yes. Ali? Brown?
Yes.
Coleman?
Abstain.
Guzman? Joyce?
Approve.
Mad Watkins?
Abstain.
Mercado? Mohebi? Perlman?
Abstain.
Poindexter? Riley?
Yes.
O'Reilly?
Yes.
Oh.
Thank you.
Confusing. I don't think I was called.
Cassidy.
You're an advisor now, Cassidy.
Oh, that's right. Oh my gosh. I forgot. All right. Carry on.
That's right.
She lost her voice.
No, you still have a voice, just not a vote. All right, next time, that leads us right into my chair's report. I I want to welcome our two newest COPRAC members, Allison Medwatkins and Adam Perlman. Welcome. We're glad you're here. Also, Erin Joyce, who's attending for the first time, even though she joined in our last term. Welcome, and thanks for hitting the ground running in the working groups already. Thanks to Cassidy Chivers for her great work as our former chair. And we look forward to continuing to get your expertise as an advisor, even without a vote. We have a lot on our agenda today, and we're going to move through it. So let's start with the staff report.
Thank you. Good morning, everyone. Just a couple of housekeeping matters. After we collected all of the pictures, it turns out Zoom will not let us set tiles for the panelists, but if you are interested in doing that on your own, you're more than welcome to. And then please do continue to reach out to either Karen or me if there are any issues with Zoom or with access to the SharePoint. I just wanted to give a brief update on 21-0003, Ethics of In-House Counsel, Business Transactions with Clients. That is out for public comment. Through COPRAC, it returns on November 19th, so we will bring it back for our December agenda. And we've received 2 comments on that so far. COPRAC also has 2 different issues that are currently before the Board of Trustees. I presented the proposed amendments to 7.3 solicitation at the September board meeting, and it received a very positive reception, very positive feedback from the board. And they ended up fast tracking the public comment and put it out for a period of 30 days instead of 45 because they believe it is a public safety issue and they would like to move it forward as soon as possible to the California Supreme Court. Public comment on that ends October 22nd. And then we will take it back to the board again to move it up to the California Supreme Court for approval. And we've received 3 comments on that so far. And then also with the board is the suggested modifications to 8.2 and 8.4. Those returned from public comment via the board. We did receive several public comments, but none of them were regarding the substantive issues of those rules. And then assuming it is okay with the working group, given the fact that we did not receive any additional public comments on point, we were going to proceed and ask that the board also move that forward to the Supreme Court for approval. I have a brief update on civility. We did receive the orders from the California Supreme Court. The civility oath was implemented. And all licensees will be taking that and reaffirming the civility oath with their annual license renewals. The other proposed civility rule changes were not adopted. The Civility Task Force met yesterday, and I will be following up with them after today's meeting. The task force would like to continue to collaborate with COPRAC and hear COPRAC's ideas for next steps in terms of civility. So civility is on the agenda today to form a working group. And then regarding AI, I know for this working group in particular, I have been sending you a ton of emails and forwarding all sorts of things to consider. So thank you so much for bearing with me. And then just kind of related to that, I really wanted to thank the committee members and acknowledge that I know that we are sending out a lot of materials, a lot of information. And it's been incredibly helpful to get your responses back so that State Bar staff and then COPRAC leadership can prepare for the upcoming meetings. It really is all of the work that you guys are putting in outside of these meetings that is helping move everything forward. So thank you all so much for bearing with our emails and sending your information in. It really helps us out. We did receive actually there were a couple of new requests for COPRAC, including a proposed rule revision to Rule of Professional Conduct 1.7, and that is included in today's agenda. And then Steve Moad from Department of Regulation is here and is available this morning to assist COPRAC with the DA ethics solar issue. And we have our next COPRAC meeting on December 5th via Zoom. And I think that is it from me.
Okay, thanks, Rachel. We're going to move first out of order to the item, the district attorney asset forfeiture and client trust accounts item. We have two people here who are from DA offices, and we're going to have them make their public comments before we start. So if you want to come up to this table and press the mic button until it turns green, and then go ahead. Just so you know, we're not taking live testimony. It's just public comment. So we won't be asking you questions during your public comment, but that doesn't mean we're not interested in listening, and the working group may follow up.
And you can hear?
Yes.
Excellent. My name is Steve Spinella. I'm a deputy district attorney with the County of San Diego. Let me thank COPRAC and in particular the working group that's been constituted for its time today. I know that you have some correspondence which had been directed to COPRAC previously on this issue. It's very comprehensive, we believe, and covers a number of different topics which effectively, in our belief, indicates that CTAP is not applicable to asset forfeiture accounts. The primary point, I think, for the COPRAC request is that seized funds deposited by our law enforcement colleagues into county-maintained asset forfeiture accounts are not received or held by a licensee under the under Rules of Professional Conduct 1.15. And I want to mention something now which was not in the previous correspondence that I think underscores that, and it's State Bar Rule 2.5. When I read that rule, it talks about annual account registration and states specifically that the full name and license number of the designated licensee is to be provided as part of that account registration. Later on in the rule at 2E, E as in Edward, it says designated licensee duties, and states further that the designated licensee shall be the primary account holder or signatory on the trust account and shall be responsible for performing the supervising the monthly reconciliation of the trust account. None of the licensees employed by a district attorney's office do any of that. We are not the account holders, as we've stated in our correspondence previously. We did not set the accounts up, and we have no ability to cut checks on those accounts or otherwise submit wire instructions, manage those accounts in any individual capacity. So when I look at specifically what's required under Rule 2.5 as it relates to what happens with district attorneys whose law enforcement partners deposit funds to a county-maintained account, it's very clear that CTAP does not apply. We believe further, and we've discussed this at length in the correspondence, that regardless of how the funds are held, CTAP does not apply. I don't want to belabor points that were raised in the letter previously, some of the previous correspondence that had been set, but it's very clear that the duties that are owed by district attorneys are solely the statutory duty of ensuring that there's due process to potential claimants. None of the requirement that law enforcement, a duty that runs to law enforcement, not the district attorneys, to ensure that seized assets are maintained in an interest-bearing account, that does not rise to a fiduciary level. And we've, I think, pointed out the reasons for that. My colleague from Placer County talked about the reality that these accounts cannot be IOLTA accounts. Instead, they would have to be placed into, I suppose, just a conventional client trust account. But we all know that non-IOLTA accounts are individualized to the client. How could we possibly deal with this when we're talking about seized forfeitures, numerous seized forfeitures, potential claimants that have not even arisen yet. It underscores again how CTAP simply does not apply to asset forfeiture accounts, regardless of where they're maintained, but very specifically for the points that we have made in the various correspondence that we've shared with the committee. It certainly doesn't apply for those district attorney offices whose law enforcement colleagues deposit funds with the county, and the licensees at the district attorney's office simply do not control that, have access to it, are not signatories. I could repeat that again, but I think it's quite clear that we have a obvious disconnect when we try to apply CTAP to these accounts, not least of which, to underscore something else which had been stated previously, is the self-assessment test and the questions that are posed of district attorneys, many of which we would simply not be unable to answer. The same thing with respect to Rule 1.15, reporting requirements to asset forfeiture claimants within 14 days. 14 days of what? We could go on, and I've made, the various district attorneys' offices who have sought the guidance of COPRAC have made all these points in the correspondence. And so I truly hope that the committee has had the opportunity to read carefully both the October 10 letter, which was sent just very recently, together with the November 12, 2024 letter that I think comprehensively discusses all of these issues. I know my time is limited, so let me thank the committee.
Thank you. Okay, any other public comment on this agenda item, District Attorney Asset Forfeiture Client Trust Accounts? Okay, thank you. Let's turn to the working group for this, and the working group is Chivers, Riley, me, and Aaron Joyce. So Cassidy, you are the lead. Could you give us an update?
Thank you. Yes, we did meet, and I think one of the main issues was that I don't think there was an issue with the fact that larger counties, assets being seized by larger counties, it's not being held by a law firm or a lawyer. So we didn't see that there was an issue with the rule applying to those DAs, basically, because they're not in control of those funds. It's really the smaller county DA's offices, and I think that's where the Monterey DA's letter comes in. We were also kind of troubled by the alert in that respect, which basically says that it does apply in the event that the DA, it does hold the funds. And so I don't want to put Aaron on the spot, but I think we were going to revisit, or Aaron was going to take a look at just evaluating whether or not there is an interpretation of the rule that would basically exclude all of these, basically all forfeited funds under this, basically the health and safety code, for all the reasons basically that's being presented here in the public opinion and in the letters. So I'm going to kind of turn it back to the working group and Aaron and Carrie as well, because Carrie brought, I believe Carrie is the one who brought the Monterey letter, or arranged that, I think. I'm not sure. But so I'm going to open it up to you guys to talk more about the development.
Can I ask, just to clarify, what do we think the working group's work product deliverable here is going to be? Is it going to be an opinion about whether and in what cases these may apply? Some kind of a written opinion?
Are you talking to me? Sorry.
Anybody who knows.
I mean, I think we were looking at the alert. I don't know. I mean, I think an opinion would have to depend on whether or not we can come up with an interpretation of the rule that makes sense.
So, Carrie.
Well,
I think that if we are unable to get around the plain language issue of the rule here, then if we're not able to get into an interpretation that they don't owe a statutory duty and then thus this doesn't apply to seized funds, then I think we would need to contemplate a rule change to ensure that we're carving this out, because I do think it's very important that this duty remains with the DA's offices, who are experts in handling these funds, who have already been handling them, and not have a chilling effect that's actually going to make people less protected by turning this duty over to law enforcement or to other agencies that are even less regulated than our profession.
Yeah, so I guess I sense from the DAs that we've heard from in public comments that they would like clarity in writing. And what's the right way for us to deliver that? Maybe it's an ethics alert. Does that seem right, Cassidy?
Yeah, sorry, you're looking to the side, so I can't tell if you're looking at me, but.
There we go. I see you.
Yeah, I think, I mean, we can do an ethics alert, but the existing draft is the one, we want to revise it, basically, if we can find a better interpretation. And yes, I think they need clarity sooner rather than later. I understand that Steve Moad is there. I do. Well, two things. One, I think we need to drill down on what we're talking about, because I know that one of the points made at public opinion during the public opinion was that these aren't client funds, but the rule is broader than that. It's other on behalf of other persons, I believe, to which the licensee owes a statutory, legal, or contractual duty, and so that could be interpreted as the public. That's who the funds are being held on behalf of. So that's like the plain language of the rule. So second is I would like to hear more explanation from Steve Moad if he's there. Did I hear that right?
He is here. Yeah, come on up, Steve.
Thank you. I want to thank the committee and the working group for their thoughtful approach to this problem. And I particularly also want to thank the CDAA working group, the deputy DAs and elected DAs from which you've heard, either the working group that wrote in separately or the DAs that wrote in separately, and various other DAs, deputy DAs that you've heard from in public comment. I have worked multi-jurisdictional cases, been a part of CDAA committees, and even worked in the same office with some of the members of the DA working group and some of the people who have commented. As always, I appreciate their legal acumen and professionalism. At the outset, I also want to say that I do not consider myself an expert in asset forfeiture, and I don't consider myself a legal ethicist. So just to give you some context there. As COPRAC member Carrie Riley pointed out in the last meeting, I was a prosecutor for nearly 20 years in a medium to large size county in California. I also want to point out that I was never assigned to the asset forfeiture unit, and of the many units that I managed in my final 5 to 7 years in that DA's office, asset forfeiture was never part of that. So I want to make that clear too. I also spent 5.5 years as a senior manager in the Office of Chief Trial Counsel for the State Bar. And for the last 3 years, I have been the head of the Division of Regulation for the State Bar, including the unit that runs the CTAP program. During my time as a prosecutor, I have had significant personal experience that shows that due to the incredible size and resource differences between the counties in California and the statutory independence of both the district attorneys and frankly the court system in each of those counties, that they each have their own way of doing things. And even mainstream processes like charging of crimes is different in every county. Doesn't mean there isn't some overlap, but it's different. And certainly those processes vary greatly. I do not claim to know the asset forfeiture procedures in every county. Frankly, I don't claim to know the asset forfeiture procedures to the T in any one county. But I don't think that what we have established here is that anyone knows the asset forfeiture proceedings in any county or in every county, I should say. And so now, having told you all the reasons that I'm not an expert in this field, I want to be very clear that I have no personal interest in the outcome of this decision by COPRAC. I'm not invested in this. I have an idea of where I think the law leads us, but I have zero interest in me being right. I do have an interest in the outcome being right, whatever that is. With that, I'm happy to answer questions. I have some comments, some thoughts. I could respond to some of the comments in the letters, some of the comments that have been made by the committee, the comments from public comment, however you'd like to proceed.
Okay, so this is not a public comment, so the working group can ask Steve follow-up questions if you have them. Aaron.
I have a question. I think one of the big problems here is that an IOLTA or a general trust account, in which multiple supposed claimants' money goes in most of the time, right, is very different than an individual trust account. And an individual trust account really only makes sense when either the money's going to be there more than a de minimis amount of time or it's a de minimis amount of money, right? Because the natural use of an IOLTA is to, let's say, clear settlement checks or to deposit advanced funds that the lawyer is planning on earning, right? So instead, what we're talking about, because of the health and safety code sections here, it is inappropriate and actually would be illegal on other statutes to stick this asset forfeiture funds after there's been a judgment into an IOLTA or a general trust account, which is the only kind of general trust, that's the only kind of general account that's available in California for handling money by a lawyer. Yet, it's impossible to expect that individual trust accounts could be made for each of these deposits. So how do you wrestle with that inconsistency?
Fair question. First of all, I just want to make clear that what we're really talking about at a base level is whether 1.15 applies, not whether CTAP applies, right? CTAP is a particular annual reporting obligation that is imposed on people who have duties under 1.15, but the fundamental question is whether 1.15 applies. So with that said, yes, there are two types of trust accounts. There are what we have named IOLTAs and what we used to call individual trust accounts, but it didn't really make sense because it didn't fit all the scenarios that would not fit within IOLTA accounts. So we have sort of rebranded it as non-IOLTAs, right? So now there are IOLTAs and non-IOLTAs. Now, and this is where I, again, am going to point out, I'm not an expert in asset forfeiture, but in our early discussions with the DA working group about asset forfeiture, we talked about this very issue. And one of the things that I was told and believed to be true is that the funds are really, they're put into sort of a general county treasurer account. Sure, that makes sense. But because the interest needs to be applied to each entrusted amount individually, that the interest is actually apportioned daily. And in that sense, there is one general account that is a roll-up of sub-accounts, right? So if somebody is forfeiting $12,500, that would go into an account, perhaps with the other in the rolled-up general account, but they're applying that interest to that $12,500 by itself, right? There's no other way for them to apportion the interest correctly to that fund in order to ensure that the claimant or the eventual beneficiary of the assets, if they are forfeited, get the $12,500 and any owed interest, right? So that's the only way they can do it. The $12,500 doesn't stay for the exact same amount of time as the $32,800 that is from a different claimant or a different situation that is being forfeited, right? It may or may not stay the exact amount of time, but if it doesn't, it makes that assessment or apportionment of interest much more difficult. So my understanding is the way that it's apportioned is it is essentially held in a separate sub-account in the sense of record keeping, and the interest is apportioned daily. In my mind, that's really no different in that sense of that non-IOLTA, right? It is essentially a separate account, a sub-account.
So you would say that that type of an account held by a treasurer would, calculated that way, would meet the requirements of 1.15a?
As far as, well, I'm not necessarily opining at this point as to hold and receive, right? That's a separate question. But the strict question of whether the account would fit the requirements, yeah, I think it would.
Can I follow up?
Yes.
I think that's not the question, so I want to focus
Okay.
on the question. And I'm
Great.
glad to hear we're rebranding, because, you know, many times I've heard there's IOLTA accounts, because the general account in California can only be an IOLTA account. When you're going to put multiple claimants' money into a trust account, are you trying to suggest that I can now call it, instead of an IOLTA account, I can open up an interest-bearing trust account and put a bunch of different folks' money in it? I don't think that's the law in California.
No, I don't
No,
think
that's definitely not. You're right. So that means either I can put the money into an IOLTA account with a bunch of people's money in it as a licensee, or if I'm going to open up what used to be called until now an individual trust account, or what we'll call a non-IOLTA account, that requires that it be held Aaron Joyce law on behalf of a potential claimant. And that's how it has to be denominated. It can't have like a laundry list of folks, because then it would necessarily have to be an IOLTA. Isn't that correct?
I'm not sure I'm following the question. I think what you're saying is, does it have to have Aaron Joyce law for one particular claimant? I don't think it does. It has to have trust account or words to that import, on it, right? And I think that if we're saying entrusted asset forfeiture funds is the name of the account for the county treasurer, that I think that might qualify. I don't know. Maybe that's not my decision, but more yours. But I think ultimately the question is, no, I don't think you can have a truly pooled account and you can just have an interest-bearing, meaning not being swept to the state bar, account that has pooled funds that you're not apportioning interest along those lines, right? But outside of that, there's no way that this could possibly make sense. I agree. But the question is, ultimately, would that meet it? I think it might.
But I think the question is this type of account even a trust account? I think that's the fundamental issue, because it's a binary question. What type of trust account can a licensee hold? It's either a general trust account, which has to be an IOLTA account in a California financial institution. Otherwise, it would be what everyone else calls until today an individual trust account or a non-IOLTA trust account. And a non-IOLTA trust account has to denominate who the claimants are. So a asset forfeiture account, which necessarily conglomerates multiple potential claimant funds after there's been a judgment of this forfeiture, and that's when it would be transferred, according to what we've seen in these letters and in the public comment, to be distributed. That is not an IOLTA account, and it's not an individual trust account. So I think trying to cram that type of an account into the scheme of the 1.15 doesn't make sense.
Okay, I appreciate your position on that. I would, just as an aside, take a little bit of issue with the fact that everyone else understood it to be an individual trust account, because I can tell you that when we tried to get people to register their individual trust accounts, nobody had any idea what we were talking about. But that issue aside, I think that the trust accounts are really the only reference to trust accounts in statute is 6211 of the Business and Professions Code. And A sets out the IOLTA account. And B says, nothing in this article shall be construed to prohibit an attorney or law firm from establishing one or more interest-bearing trust deposit accounts or dividend-paying trust investment accounts, as may be permitted by the Supreme Court, with the interest or dividends earned on the accounts payable to clients. Right now, putting aside for a moment this clients issue, which I think essentially is kind of a misnomer that everyone has adopted. We call it a client trust account, but clearly it's not just for clients. It's sort of a fast way of referencing what this is. But the point is that I think if the fund is established with the interest or dividends earned being paid to whoever that beneficiary is, whether it be eventually the claimant or the public agencies for whom the forfeiture is ordered, that appears at least under 6211B, and I think arguably under 1.15 to be permitted.
I'm sorry to interrupt and just to monopolize this, but then I'm very confused here, because are you saying that under Business and Professions Code 6211, an attorney can, instead of operating an IOLTA on benefit of their clients, put all of their money into an interest-bearing account where the interest is not going to go to the State Bar to fund legal services, but instead will be held in that type of an account? I don't think that's appropriate.
No, I'm not suggesting that. What I'm suggesting is that in this scenario where clearly an IOLTA would be contradictory to the statutory scheme, there is a way that we can reconcile these things such that both things that appear to apply would in fact apply.
The reconciliation, though, appears to be different than at least practice that I understand and what Aaron's described, which is when you're not in an IOLTA context, you're opening individual accounts that are designated for particular purposes.
Yeah.
So what you're suggesting is that the reconciliation where you need an IOLTA account, which can be pooled funds with sub-accounts tracked, and a separate client trust account where the interest is not paid to the State Bar, paid to the individuals. As long as you track the sub-accounts, that would be okay? Your opinion?
So, I mean, if you're talking about the monthly reconciliation, is that what you mean?
Yeah, except what I'm really getting at is Aaron's point, which is these are individual accounts that are open for a particular purpose, particular client, and they're actually, you have to go to the bank and do it. It's not an IOLTA account that you just have and use. What you seem to be suggesting is that there's one big pool and these treasurer accounts would qualify under the non-IOLTA category, but that's not how it's done now.
I don't know that that's true. My understanding is that is how it's done now, because otherwise they couldn't apportion the interest. That they are in fact putting them into a separate account. It's
I mean,
a sub-account.
for non-treasurer accounts, anything that's not an IOLTA account is an individual trust account that's open for a particular benefit of a person.
Right.
That's what I'm saying. It's not done as a pooled account. That might be far easier for California lawyers to do, but it's not how they're treating non-IOLTA accounts right now.
I don't think it would, sorry, I didn't mean to interrupt.
Sorry, would it be an exception for these particular entities to do that, or do you think that every California could now have one big pooled account with sub-accounts for all client trust accounts that are not IOLTA?
No, I'm not advocating for that. I guess the issue is that I think as a practical matter, the county treasurer does in essence open a separate account for each value that is being forfeited or potentially forfeited, right? And it's rolled up for accounting purposes into this is the asset forfeiture fund and this is how much money is in it. But they are in fact opening a separate account that is being tracked separately, interest is being apportioned separately. That's very different than me going to Bank of America and saying I have these unrelated clients from unrelated matters. They have all these different money going into this one account and they're all going to be earning interest and it's going to be paid to these clients. That is a virtual impossibility and is not anywhere close to what I'm suggesting. I also agree to the extent that you were earlier asking about the monthly reconciliation, and that is that the monthly reconciliation in a IOLTA account in some ways, at least in theory, could look very different than a monthly reconciliation in a non-IOLTA account, right? In a monthly reconciliation of a non-IOLTA account, the account journal and the client ledger are the same document, right? But Rule 1.15 requires that at this point, that even if you have a non-IOLTA account, that you have to have an account journal and a client ledger, right? So, I mean, clearly there are things that we could improve about the rule if that's what we're looking to do, and make things easier for general lawyers and not just for DAs. But I don't know that there's a carve-out. I think ultimately the question is, are they receiving and holding funds, and do they owe a statutory duty? And if so, then we The rest of it, we need to figure out how to technically accomplish.
Okay, let just assume that we reinterpreted, and I say because I have a different understanding of the second category of non-IOLTA accounts, but let's say we reinterpreted it so that the treasurer's account, the pooled account, list of accounts, where the interest is paid not to the State Bar of California, but to the individual accounts holders, the beneficiaries. Would we then have just two types of trust accounts in California? Not in the treasurer context, but in private practice. You have an IOLTA account and you have a non-IOLTA account. One of them pays interest to the State Bar. The other one doesn't. The interest is calculated, apportioned among each sub-account. Would that qualify? Is that what we're thinking here? Because otherwise there isn't a rule that applies to everyone, because that's not, Aaron, am I on the right page with what you're saying? Because my understanding is the same as what you described. These are not pooled accounts. Non-IOLTA accounts are individual accounts. They have a different account number. They're dedicated to some particular purpose.
Right, and they might have multiple payments, like an example, like the perfect example is like, you're the hapless family law lawyer that's holding the sale of the proceeds until the MSA is settled.
Right.
So now I have claimant A and ex-husband. That's what it says on the account. So here, the reason why I think this is so hard to understand is that an IOLTA account is where the only place a licensee that is holding funds can pool funds. And just as you described these individual like sub-accounts, anyone that has Quicken or QuickBooks or Xero for their IOLTA has those sub-accounts. They actually open those, and that's how they have those client ledger cards as reports from their account journal, but it's all one account. Just like these pooled accounts, which are asset forfeiture accounts for which no interest could ever go to the State Bar, is not a trust account. That's the whole point, and it's being held by the treasurer of the county, who is not a licensee, unless I guess they happen to be a lawyer also. Is that, so all of a sudden now that county administered account becomes under 1.15? I just don't believe that was the intent of the rule, or even on its face is what the rule's requiring.
I can't speak to the intent of Rule 1.15, but the language of the rule says that any money entrusted to a licensee where there's a statutory duty, if they receive and hold, that it applies, right? Now, if we want to change the rule, we can talk about that, but that's what the rule says. Now, to your point about that anybody with Quicken can do this, I would argue that's not true, because if they go to B of A or Wells Fargo or whatever bank that they have, they're going to apportion the interest on a monthly basis, or they're going to say, this is the interest you've earned, and then those sub accounts, in their Quicken account are going to say, okay, I had $12,000 from this person for 3 days, I had $8,000 from this person for 7 days, and whatever else. They're not going to be able to apportion that interest, right? That is the fundamental difference between what the county treasurer is doing and what the bank is doing, and what somebody with a Quicken account who is, has a pooled account at a bank is doing. That's not possible. And so the difference really isn't, I don't want to get caught up in the semantics of a pooled account or a sub account. Really what they're looking at is they are separate accounts that are being rolled up into, okay, this is how much asset forfeiture we have. But in essence, they are opening a separate account that is earning interest on a daily basis for each of the claimants and for each of the, public agencies that are receiving the benefit of the forfeiture after the fact.
And just one last question, and then I'll really be quiet. When you keep saying that it's a licensee holding this, is it your understanding that in these individual counties, the county treasurer has access and is opening and signing on these accounts, or that the DA and these individual accounts are being held by they're not actual county accounts, that every time there's a election, someone else goes down and changes the signature card? Is that what I'm hearing?
First of all, I have no idea how it happens, but I highly suspect that's not how it happens. That they are in fact county accounts, but that doesn't mean that when they get a new asset forfeiture amount, that they wouldn't say, yep, we got another one, Bob, we got to open a new account, and then we'll add that to the roll-up of the total asset forfeiture funds, right? So they would designate it as, account number 105896 2 instead of what came before.
Novella.
Yeah, I had a question about the statutory language in the rule. So when it says the lawyer receives or held funds, I think an important qualifier on that is for the benefit of. So it's either for the benefit of a client or for the benefit of a other person. And then person is defined in a way that to me would suggest it couldn't just be like the general public when you look at the definition. So I guess I'm having tension with like how to construe who a district attorney is holding funds for the benefit of, when like the concept of the benefit seems at tension with the process of like seizing something.
Typically the funds, once there's a court order for the DA's office to distribute the funds, meaning they're not going to go back to the defendant, they're going to be distributed. There are a bunch of different stakeholders who would have a claim to those funds. And so that's when we're looking at the language of 1.15A, it's the fact that the DA's office owes a statutory duty to, sometimes it goes to Sacramento, sometimes it goes to the DA's or other DA's offices itself. It depends on why the assets were seized and then what the order distributing those funds says. Does that make sense?
Yeah, I think so. I'm thinking of there's a Wood v. Superior Court case, a published California opinion that like has an analysis of district attorneys and what duties they owe people and how they're different from lawyers who owe a duty to a particular client because they owe a duty to the public. So I guess I don't know how to like conceptualize the duty to the public and then how that breaks down to duties to particular members of the public when saying like, does this count as a duty to a other person for purposes of the rule?
I think that the health and safety code imposes a duty on the seizing agency and law enforcement and the DA's offices who are conducting these proceedings to, in essence, preserve the value of the funds, which means earn interest on the funds, right? That's why it can't go into an IOLTA account, et cetera. So one could argue that whether it is for example, if a claimant has made a claim, making them the claimant, right, then it seems like they would very easily be the person that to which that duty is owed if the court eventually decides the money is supposed to go back to that claimant. And arguably it's, could be, certainly if the court decides it's not, then throughout the proceeding there has been some duty to preserve the value of those funds, whether the claimant was there or not, whether that person is the prosecution agencies that get the money, including the DA's offices, or whether they're preserving it for an unnamed as of yet claimant who may present themselves, right? They still have that duty, and it's a statutory duty, and that seems to meet the definition in 1.15. The other issue, well, I guess we haven't had a conversation about receive and hold yet, but I'm happy to address that when we do.
Okay. Other questions for Mr. Moed while he's here? I think the task of the working group obviously is to reconcile these different things. It's not that easy to do, but I think we will also have the working group reach out to you to continue that conversation. Thanks for your time today. And the public comments that came from DAs, we may also have the working group get your perspective after today as well.
If I can add one other thing,
Please.
Just the letters from both San Diego and Monterey raise issues that address the receive and hold, right? Scenarios where I think it's unavoidable to say that the DA's office receives and holds. For example, Monterey talks about one of their investigators actually seizing the money. And the San Diego letter also talks about in various counties, this is what happens. In other counties, this is what happens. And at least in one of those scenarios, I think it's inevitable to say that the DA's office receives and holds. So I'm happy to discuss any of this with you at any time.
Great. Cassidy.
Sorry. And we can probably just continue this conversation because I kind of have two questions that are probably more specific. One of the questions is the public comment of the person from Mr. Spinella. Do you have any input on whether or not, like, let's put aside maybe 1.15 doesn't apply, or if it does apply, what about Rule 2.5 and 2E, which has to do with, like, the account registration and the designated licensee? That seems pretty incompatible with the process. How do they comply with those rules? I mean, putting aside how do they comply with 1.15? So
Yeah.
That's something that we'll need to look into. And then you had mentioned at the outset too, you said that CTAP is different, is there, and I don't know how we're going to approach this, but would there be a way that we could exclude these DAs from CTAP compliance? You know what I mean? Like, is there at least some relief in that realm? I guess is a thought I had.
I don't know if that's a rhetorical question or if that's a question for me.
No, I mean, like, it's really hard to amend rules and, and comments and all that, but is there a way to deal with it through CTAP that's more streamlined and more practical, basically?
Yeah, of course. I mean, I think ultimately if you determine that 1.15 applies, then that creates some issues that I don't know would be resolved by exempting them from CTAP reporting. But that said, I think you could talk about amending the CTAP rules to exclude them from the annual reporting. That would make sense. I will say that this entire conversation arose because initially, when CTAP first went into place, nobody was thinking about DA asset forfeiture funds or otherwise. The first year of CTAP, the answer was no, none of them reported it, which is understandable because there was no question, let alone an open question. And then one of the DAs in charge of asset forfeiture reached out to me and said, should I be doing this? And I was looking at receive and hold and statutory duty and saying, yeah, it looks like you do. And that's where this discussion with the working group started, and it's been going on for several years. And we have temporarily, exempted them after consulting with the Office of General Counsel based on the open legal question that was pending before us. I do agree with I don't want to say urgency, but the need to have this issue resolved sooner rather than later, because at some point we need to decide whether they need to say yes or no. I will say that there are some practical concerns that they have raised about these, the self-assessment questions. We have frequently asked questions on the website about how to deal with the self-assessments, and those frequently asked questions say, look, if a particular question doesn't apply to you, you can say no, right? It's not a bad thing. It's not a thing that says you're in trouble or you're going to be audited or anything like that. But if certain things don't apply, which in this case I could see don't, then they would say no. And that doesn't, well, I've already said it was not going to trigger them for audit. There's no negative consequence of them doing that.
I mean, the obvious initial question is who even in the office is going to fill that form out?
Well, I think that Ms. Riley mentioned last time that, potentially DA's offices, if they're doing this, would have to fill out that form.
Every single one of them?
Well, that was, I don't know if that was the statement from the last time. I don't know that I would take it that far, because we have the analogy, frankly, that I think is probably less apt than this situation, but the analogy to a civil lawyer who does only document review, never talks to clients, never whatever, that is sort of can say no. I think arguably, ultimately, if the duty is not being conducted by other people in the firm, it would eventually fall on that person. And so, maybe they should be, but I don't know that that's the situation here. I think the situation here would be those who during the reporting period were assigned asset forfeiture duties, and those supervising and managing lawyers in their chain of command. So ultimately, if you're asking me, for example, if the elected DA would have to fill it out, yeah, I think they would.
But there might be others, for example, people who were involved in litigating the asset forfeiture.
Yeah, oh, absolutely. Yeah, I think that they would. If they owe a duty under 1.15, which depending on how you come out on that issue, then yes, they would. But
Okay. All right, thank you, Mr. Moed. That's very helpful. And the working group will follow up with you and the other people who made public comments. I think we have a better understanding of the scope of the issues. Any other questions before we move on?
Inside the committee, not to the guest.
Okay. Go ahead. Sure. Thank you, sir.
Yeah, so I feel like I'm understanding the depths of the, I feel like I'm understanding the depths of the ocean, but I realize I don't think I've seen the alert, and I also need to roll back to the beginning for context, because I realize I don't know how this is now on our table. So it definitely would be helpful for me, but it probably would also be helpful for our new members to have some context about what we're saying, because we're diving really deep, but I'm not sure. And like I say, I just Googled not Google, but just sorted in my email, and I haven't seen anything, and it hasn't, each time we've had this on the agenda, there's been nothing attached. So I do think it's really important, if we're talking about things, that the item is attached to the agenda or we have it. Otherwise, we should strongly consider not talking about things that we don't have the information about.
You want
Thank
even
you.
more information, Raquel?
No, I said we're at the bottom of the ocean, but I don't think we got to the top. What's the context? How did it show up on our table? Why are we talking about it? And I realized, because I heard someone say something that seemed like there was already an alert. So I just realized having not seen anything, I don't know what we're exactly doing.
I think that's a good point. This is the context for the whole discussion. So when the working group comes back to the committee with what I think will be a draft of a resolution to the issues that are addressed here, it should include the context, what is already out there, what started this. We got a little bit of a feel for that, but the actual draft alert, is it a draft?
Yeah.
Draft, so including that
But
context.
it was, I think Novella sent a, thanks Novella. It was part of the materials of our December meeting, is the draft alert and the working group. So the way this came up, I think, and then maybe Rachel can speak to this, and I think Mr. Moad alluded to it, is that these DAs were questioning whether or not they had to comply with Rule 1.15. Then this issue came to us about, what is our interpretation of the rule? And then I believe staff drafted the ethics alert, and we are mulling it over. And meanwhile, we formed this working group to mull it over, and we've received outside input from the Monterey County's DA's office and San Diego County and I
Placer
believe
County and multiple
Placer
others.
County. Yeah. And so we're, basically we're trying to thread this needle to figure out how to deal with, the confusion as to how this rule applies or does not apply to asset forfeitures. So if you go back, Rachel or Raquel, sorry, and look for the September 12th materials, the alert would be in there, the draft
Okay.
alert.
Thanks. So the idea, I think, for the working group is that you'll come back with a draft that will resolve all these problems in elegant fashion.
Yes, yes, we will have that all worked out. But I mean, there's, frankly, it seems like there's additional issues aside from Rule 1.15, which is the 2.5 and the state bar rules, and then the CTAP compliance. So, yeah.
Only if that applies. I think if they're not rules, they're not.
If we can find an interpretation to say that Rule 1.15 does not apply to these forfeitures, and then those other rules would not apply in requirements. But the state bar rule requirements may actually inform that analysis because it's just completely, it could show that it's completely incompatible to have the main rule 1.15 apply. So yeah, those are my thoughts.
Okay.
That was helpful. Thank you.
Sure.
Any other comments on that before we move on? Just looking at the screen for raised hands. Okay. Thank you to everybody who provided input on that question. The next item is civility discussion, which I just want to get a quick refresher from Rachel, and we are today just putting together a working group to be ready when the inevitable question comes, what should we do next? So Rachel.
Yes. Specifically, the order from September 25th asked the State Bar to explore the possibility of codifying existing case law, reducing requests for attorney's fees based on an attorney's incivility. So that is the directive that we've received from the California Supreme Court. Staff is pulling cases on that issue that we can provide to the working group to help them move forward and looking at that issue and any other issues that the working group deems appropriate.
For more context, there's a civility task force that has been working on this for a couple of years. They went through a variety of different processes to get some recommendations about civility ramifications and presented those to the Supreme Court, which declined to adopt them based on specified First Amendment grounds in that September 25th order, and then suggested that it would go back to the Civility Task Force and to us. And so the working group will work with them. I know some of the members of that task force, and they are reconstituting to just consider what the next steps are. So it would be in concert with them. So can we have some working group volunteers for the Civility Task Force? Sorry, Civility Working Group.
Couple of questions. Is there a date that we have to have information back to the court, Rachel? Is it time sensitive?
No, there was no date given.
Okay.
And so at this point, I think it's mostly just getting the working group together so that we know who from COPRAC is going to be working on this issue and then who's going to be working with the Civility Task Force as well and to figure out where to go from here.
And the Civility Task Force that exists is comprised of whom? Not the individual names, but
It's
overall.
California attorneys at least, and some judges and former judges is my understanding. And they've been constituted for at least a year, maybe two or more, and came up with recommendations that the Supreme Court had some reservations about and reset. So it's lawyers and judges and former judges who are considering ways to improve civility among lawyers, right? A worthy goal, but a very difficult one, as we see.
I would be interested as a public member.
Okay, thank you, Raquel. Who else would like to be on the working group for civility, maybe to be ready to coordinate with the Civility Task Force?
I'll volunteer.
Eleanor?
Yes, I'll volunteer.
Okay, very good. Very civil of you. Thank you. Let's say at least one more.
I would volunteer.
Adam Perlman. Thank you, Adam. Okay, very good. We won't take it as a sign that Aaron got up and left the room when we talked about civility. That's okay.
No, I'm so sorry. I didn't catch the lad before he left.
Okay, is 3 a good start for the working group? Okay. Sit by your phones and wait for the task force to call, that I suggest. Thank you all for volunteering. All right, the next item on the agenda is artificial intelligence, and we are going to turn to Raquel and Eleanor for an update.
Sure. So I don't know if Raquel, did you want to update, or would you like me to, or shall we do it together? How do you handle it?
Tag team.
Okay.
So I can start now.
Sure.
Basically, since the last meeting, we did have a working group meeting to just reassess where we are. At that working group, we also received the Supreme Court letter giving a directive to relook the practical guidance we did in 2023, see if if it applies, should we put some more firm changes around rules, look at agentic AI. And so we talked about that generally. We also talked about external members to the committee, which we had on the first go around, and what kinds of things that we thought would complement the members of COPRAC. So we have successfully gotten 2 new members that we wanted. One is Daza Greenwood, who was on the original task force, and I'll just say is all things AI as well as agentic AI. And so we had some interest with connecting to what Stanford University is doing. And so Daza is well entrenched in that program. And then we also got an acceptance from Daniel Rodriguez from Northwestern and University of Law School, former dean of that law school, who we wanted to get a perspective of what is being taught in law schools around AI and how that more current thinking about AI, so what are new lawyers going to be coming into the field. So they both have accepted to be part of the working group. And so at this time, we think we have the members that we need. And I have a question of staff, which is twofold regarding the letter from the Supreme Court. What was the
Raquel, before we go to that, could you just quickly give us, for the new members, a little background on how we got back to the AI question again? It came from the Supreme Court.
Well, when Rachel took over leading the committee a few months ago, suggested, well, let me go back a little bit further. At the beginning of 2025, I guess, Erica, who was formerly the staff for this committee, talked to our committee AI and said, should we talk about AI? It's been a couple of years. And then so we said yes, but we never got together. And so when Rachel came, Rachel said, yes, we should. And so because she felt that the field was changing rapidly enough. And so then the Supreme Court letter, which everyone, hopefully the new people have received, came. And so that really was just something added to what we were already going to talk about. It's not particular. I mean, it's important because they asked for it, but it wasn't the reason that we're reconvening. It's more time has passed since our initial work on the subject.
Right, and if you haven't seen it, at least 2 years ago, I think we issued the AI guidance, which just goes through how the current applicable rules will attach these issues. But even at the time, the experts were telling us that it was going to change so quickly that it should be continually monitored. Okay.
I think that was November 2023 that we issued that. And yeah, we
And
definitely
go in AI terms.
to revisit it. Sorry.
questions I have, Rachel, what was the impetus for this letter? Is there, I'm presuming this didn't just show up in somebody's email, there was some kind of conversation or context that would be helpful to provide. And then this too, maybe it doesn't say it has a deadline, but it would be helpful to the group if staff is thinking we should be working on a specific timeframe.
Yeah, I do not know if there was any background to this or discussions that led up to this letter. If there were, I'm not aware. And I think in terms of timing, again, the court did not give COPRAC or the bar a deadline. But it looks like they have identified this and civility as their kind of two big issues that they would like us to take a look at and start working on.
So, okay, appreciate those answers. In other words, this is Supreme Court. So does the state bar say, oh, this is Supreme Court, we should do this post haste? Or is it like, oh, let's take a year? So I'm just trying to get a sense of what is in some way, since it is the Supreme Court, is there some unspoken rule or expectation from the state bar, but probably also from the trustees, on how rapidly they want this to move? And I'm asking this so that we as the working committee can organize ourselves in a way that we are moving consistent with what the unspoken, perhaps, expectation would be.
I'm going to go out on the limb and guess that it should be done timely.
That's real helpful.
And keep it moving.
That's
With all deliberate speed. I mean, I think when we put together the AI guidance years ago,
we had a deadline.
We did have a deadline, but I think that with these two policy priorities for the California Supreme Court, it would be a good idea for us to prioritize both of those and keep them moving forward as the same way we did last time.
I agree with that, and I will just note that if we are looking at making changes to the rules of professional conduct, issuing an advisory ethics opinion, adding comments to the rules of professional conduct, all of those things require the public comment process, both at the COPRAC level as well as the Board of Trustees level. So just the nature of getting there takes quite a while once we have a final product that we are trying to move forward as COPRAC. The practical guidance was a little bit different and could be issued sooner because it did not need to go through all of those steps. Looks like Kathy
has her hand up.
Yeah.
Hi, everybody. Yeah, so I just wanted to add a bit more context. In terms of the letter from the Supreme Court, there have been a number of highly publicized cases of attorneys misusing generative AI, from small firms to large firms. And so I think that that's what prompted them to ask us. And COPRAC was, it was kind of part of the idea that we would look at this year. Out of the two, and in terms of timing, I would say that the priority would be the Gen AI, as that's moving very quickly. Civility is one I think that's going to take a little bit more time because they're specifically asking for a rule change. And that's going to require all the public comment. So I think that would be kind of the time frame that we're working on, that maybe we could get the Gen AI stuff done the first half of the year and civility maybe the second half of next year. That's just kind of guidelines, I would think, but the committee can definitely determine what's going to work best for them. The Supreme Court much rather us get it right than rush. So I hope that's helpful, Raquel, or to the committee.
That's helpful. I was thinking June 2026, based on, Rachel, what you said about the processes. That probably is the earliest.
Another threshold question, as we talked about last time, is if we're doing updated guidance, meaning we're talking about how the current rules govern these things rather than recommending new rules, it's more likely to be done by then because the working group's product, these are updated. we're still tracking and watching what I think we identified during the last AI process, which is at some point, generative AI is going to be providing legal advice directly to human beings if it isn't happening already. And in what circumstances the people who are responsible for that are under the rules and the other statutes. So that's something to keep in mind as well. But if you're not talking about a rule change, which at least in 23 we certainly weren't, we were just talking about how the rules applied to the circumstances. But that timing sounds good to me.
Eleanor?
Yeah, that seems reasonable to me, assuming we're not talking about a rule change, which at this point, I have no reason to believe we are. I'll just add a couple of things. I think for new members' benefit, Daza's background, he is working on agentic AI and other AI-related things with coding at Stanford, which is very relevant, and we want to know more about it. But his background, and I think he still continues as a researcher at MIT in an area that's called computational law. And so he's been working a lot on AI at MIT in this area for a long time, and he brings a lot of knowledge about how AI and generative AI are being used in the law, and how people think it should be used in law in the future. Dan's background also includes legal ethics. So I think he'll be an interesting addition because he is considered an ethicist as well as an educator. And as Raquel said, he was the dean of Northwestern Law. So we're happy about those two members. I think we're open to additional if anybody has recommendations or thinks we're missing perspectives. We'd love to hear from you. And we do have a request for the staff, which would be to help us update the research that was done for the prior committee or working group, rather, to look at any changes since we last published the guidance from other bars, both in terms of, I'm not aware of any rule changes related to AI, but if any comments have been added to rules that we are unaware of and additional or updated ethics opinions, we love the staff's help in gathering those for the working group. And also be interested in California judge standing orders and any local rules on this. And we don't need just a kind of a survey of anything unique out there. We're aware, obviously, of the ones that require lawyers to sign saying whether they used it and that they exercised independent judgment. But anything other than that that's out there, we'd love to know about.
Okay, that'd be great. So let me also just ask whether any of the new members or actually anybody else would be interested in joining this working group, because there is a great set of personnel, but it's a relatively complex, difficult thing to do. So
I'm actually very interested in helping with that.
okay.
So am I.
And Allison.
Terrific.
Okay. Great. And Adam. Everybody wants in.
How many members can you have, Jeff? Are we?
Yeah, we can't get quorum with our working group.
It's too big.
Our working group cannot hit quorum, otherwise it could be a violation of Bagley-Keene.
It would have 5 committee members. The other 2 are non-members, non-committee members. Is that too many?
I thought we're adding 3, and I already have 3 on here. Am I missing?
But they're not committee members.
No, there are 3 committee members.
We have 3 committee. Nima is the lead.
Yeah.
Okay, that would be 6.
That's
Okay. Okay. Adam's going to hold, and he'll do the next one.
Okay.
And Joyce and Alice and Med Watkins, because they spoke up.
And let me just say, because Eleanor actually said something different than I said. So let me just be explicit, though, to those who joined. Making meetings and making yourself available is going to be really important. And so that was why I said not more committee members, because it's people they like to be on a committee, but they don't like to go to meetings. And we have external people who, one of them in particular, Daza, said, like all these meetings and trying to figure this out is not going to work well for him in his calendar. So I just want to be very transparent. Not only, to you guys because you're new, but I think also to us that are on the committee,
because we're talking June 2026, and so it's going to move rapidly, and so we need to be mindful, and if we can't if any of us can't make the commitments and we realize that, it's okay to say I can't do it and drop off, because AI is going to be here for a while. So I just want to say that in the nicest possible way.
You cannot send an
Over.
AI agent to those meetings.
Maybe we
not
could
permitted.
practice.
Okay. All right. Anything else on AI before we move on? Okay. The next item is client file releases and retention duties. This one's been trailing along for some time. Yeah. Is anybody from this working group here and ready to tell us what is happening, what the next steps may be? I think Mary Grace Guzman is the lead, and she's unavailable today. But we also have Ali Mercado and Poindexter. Does anybody have any, really even a quick update?
Just from the staff perspective, we did try and incorporate some of the public comments, but we needed additional direction from the working group, because in order to incorporate any of the comments, it would really change kind of, I think, a lot of the opinion. So public comment ended in May of this year, and so now it's just a matter of figuring out, do we need to make changes to the opinion, or is it good to push through to the board at this point? So I can keep it on the agenda for December.
Yeah, so the task for the working group for the next meeting will be to answer that question. And if changes need to be made, what are they? We'd like to have them circulated before the meeting, if you can.
I think that sounds perfectly reasonable. Rachel, could I just ask, in Mary Grace's absence, that you put a meeting on the calendar for the working group, or try to get that scheduled in the next few weeks so that we can make sure that this moves ahead?
Yeah, no problem. Happy to do that.
And would you circulate the comment and the updates? So, okay, great. Thank you so much.
No problem.
Okay, it's 11:52. We're just around the lunch hour here. So I'm going to suggest that we take our 1 hour lunch break, and we'll come back and talk about the lawyer's expert witness opinion next. Sound good?
Mm-hmm.
Let's do it. Okay, welcome back, everyone. Before we start the afternoon items, I thought it would be a good idea just to get a sense from our new members, a brief description of their practices, because it's helpful when we're thinking about things related to working groups and other things, and we will be happy to tell you about ours at some point. If you get people on the committee started talking about themselves, they might not stop.
Yeah.
But maybe we'll start with Adam and just give us a sense of your practice.
There we go. My name's Adam Perlman. I do criminal defense. I've been a criminal defense attorney for 22 years. Before that, I was a prosecutor in the Ventura DA's office in Ventura County. So right now I practice in Ventura and Santa Barbara because I live in Santa Barbara. The only other kind of law that I do, and it's maybe 10% or less, I haven't counted, but is litigating domestic violence, restraining orders, civil harassment orders, because there's a lot of spillover from criminal cases into that arena. And I try my hardest never to get involved in family law cases. That is my goal in life.
That's
So
great. Okay, good.
that's
Well,
what
it's
I do.
really helpful to have somebody with a criminal law practice on the committee, and that's, I mean, a lot of the things that are even on our agenda today touch on that in multiple ways. So thank you.
Yeah, I was a DA for 10 years, so I also have a lot of experience and background in that as well.
That's great. Okay, thanks, Adam.
Yeah.
And Allison.
There you go, I'm great. Hi, I'm Allison Med-Watkins. I am currently an adjunct law professor at Thomas Jefferson School of Law in San Diego. I teach contracts and also professional responsibility. I've taught federal income tax, I teach sometimes California civil procedure, and yeah, so I have a background in academics. As well as that, I'm originally from New York, so I'm actually licensed in both states, in New York and California, but I'm inactive currently in New York. I, in New York, was a foreclosure attorney. I represented banks in foreclosures. It's a judicial process out there, unlike California. One of my clients actually brought me to San Diego. I did then compliance work internally for mortgage servicers and banks. And then I moved that more to general compliance, including for some semi-government entities, and then got into being an adjunct professor.
Great. Okay. Well, lots of very interesting, relevant experience there as well. Thank you. Yeah, if you want any guest speakers, I'm sure the committee members will come to your class and tell you all about it. Erin, tell us about your practice quickly. If you want.
Certainly. I was happy to be able to participate, or maybe.
Yes, press that. Press and hold.
Okay,
There you go.
takes a few moments. A little bit of a delay timeline. I'm Erin Joyce, and actually this was like old home week coming in here, because I do remember a baby shower in this room with all the balloons, and it was brand new, and so everyone couldn't use tape on the ceiling that might leave marks. I'm a former state bar prosecutor of over 18 years, and I now have my own ethics practice in Pasadena, where I represent a lot of applicants getting through the moral character process. I do advice and counsel to lawyers to avoid contact with the bar, and unfortunately or not, do a lot of proceedings and investigations with the state bar.
Right. Okay, very good. Yeah, also, I mean, on all fours with the committee's work, of course. So you had your baby shower in this room?
No, no, but I did bring my daughters, and my baby's 18, and she was probably like, I don't know, 3.
Okay.
So I mean, many, a lot of memories of this building.
Okay. Some good even.
All of them.
Oh, good.
Lots of good memories.
Okay, let's move to the next agenda item, which is a discussion of the draft 20-0001, lawyer as expert witness. This is back from a second round of public comments that went out for a second round of public comments because scenario 3 in the opinion was vastly revised. And then we got many public comments about the questions that are here, which I'll run through. And then I might just ask some of the other members of the working committee to just sort of walk through this. What we're looking for today is the committee's input on these questions in sort of general, and we can give you context for the way these public comments came up. But it's a slightly new direction for the opinion, and we wanted to pause and just get the committee to give general thoughts on these questions before we start drafting in this direction. So Erin, do you want to run through those? Do you have
Let me just, you know what?
those in mind? Okay, I'll start while you pull that up. The working group is me and Carrie and Vikita and Erin and Eleanor. And the second round of public comments came back. We had a working group meeting where we refined what we think are 3 categories of changes that we would make based on the public comments from the most recent revision. And this is for the committee to discuss. So let me just run through all 3, and then I would just like to get input from folks if we can, including from the working group members who are up to date on these issues. So we're considering revising it to state that serving as an expert in some instances may be the practice of law, as opposed to what it now says, which is a kind of a categorical statement that it is not. And that categorical statement comes from an ABA opinion that is relatively short and just sort of says this is not the practice of law. That's one. There may be some instances where being an expert, if you're a licensed person, could be the practice of law. So that's one concept we want to talk about. The other one is making a distinction between a consulting and a testifying expert, because those are different functions, and probably a consulting expert is closer to the practice of law than a testifying expert would be. And then making a distinction between those in that question of whether being an expert is the practice of law. The third is making scenario 3 stronger, just to say what at least the drafters thought, which is the duty of loyalty would not permit you to do both of these things in a conflict situation, meaning your firm represents somebody, you're an expert opposite that person. That did not compute for many of us, and we revised it to say it probably wouldn't work, and a lot of the public comments were saying it definitely wouldn't work. So we're leaning toward that more strong conclusion on scenario 3. So let me start there. And for the working group, if you have other things to add, we also want to get the committee's reaction, because it's a relatively significant thing to say, being an expert in some instances may be the practice of law. Anything to add on that one, Aaron?
I do think that was well, I think that main issue was very important to consider, because depending on, I mean, we discussed within the working group the fact that most of the time when someone is approached to be giving a legal opinion type of expertise, they will be as a consultant first. So they may very well be providing legal advice with respect to, like, what are the best, who are the proper defendants, what's the statute of limitations, what's the, how do you maybe plead something? That is all providing legal advice. So, and those kind of agreements with that, they start out as a consultant, and then if their opinion, once they've done the research or their analysis, is going to be favorable, then they could be designated. So
yeah, I mean, there's a couple of challenges here that we'd have to work through, but also, I mean, one is that if we say that being a consulting expert is always the practice of law, but testifying expertise might not be, then you have to come up with some distinction about the difference between them and why it isn't all of a sudden the same person doing the same thing in a different role is no longer the practice of law. The other tension is that non-lawyers are experts all the time. Most experts are not lawyers. So there's a higher standard here for a consulting expert who happens to be a licensed person. Maybe that's okay, but just thinking through that. What does everybody think about the distinction between consulting and testifying experts on whether that is or isn't the practice of law?
Can we say a little bit more about why the distinction was recommended? Like, because I guess I'm not seeing it as a clear line.
Yeah, I think
I can
that from
appreciate, I guess I'll say one more thing. I can appreciate the similarity to the lawyer as a witness issues that can come up, in certain cases, but those really only apply when the lawyer is actually on the case as well. So I'm not sure it helps us that much, but are there other reasons we think that we should make this distinction?
just from the overview perspective, we just sort of tacitly adopted the ABA opinion, which said that it was not, period, end of discussion. And the public comments said that a lot of things that experts do, especially in the consulting role, very definitely could be the practice of law. So it was with that in mind. And the ABA opinion is not fully fleshed out. It's a relatively short one, and a lot of people have taken it and run with it because it's a conclusion that people like, and it's easier to have a bright line rule like that. But I think the public comments were, it's not as clear cut as yes or no, depends on what you're doing. As Aaron said, if you're a consulting expert and you're giving advice about statute of limitations, strategy, or whatever, that's pretty close to being the practice of law. So that was the sort of origin of it. It would be just not to rely on the ABA opinion that says it's never the practice of law, because maybe the conclusion is simply that it might be, and the licensee has to determine whether what they're doing is the practice of law. Good luck trying to determine that, but at least raising the possibility that it could be is a change. Novella.
Yeah, I actually found the explanation you just gave more helpful because than the consulting versus testifying expert distinction, because you went into different scenarios of what the expert is opining on and how that relates to the practice of law. And in reading the draft overall, I just realized I didn't really understand the rationale of why it was why I guess you said the ABA opinion made that distinction. So I was looking at Barron v. City of Los Angeles, where like the California Supreme Court is talking about like the gray area of trying to be like, this is the practice of law, this is not. And I felt like that one sentence in the draft didn't really reflect the nuance, whereas the explanation you just gave went more into that and was clearer.
Yeah, I mean, my impression is that the ABA opinion made a brighter line rule because it's easier for people to use in their practice, but also because many experts are not lawyers. And so there is a hesitation to make that role for licensed people the practice of law, and not necessarily wouldn't be for a non-licensed person, obviously. So you also have the possible implication that if a non-licensed person is a consulting expert, is that UPL? Because if a lawyer does it and it's the practice of law, if a non-lawyer does it, it's not?
Well, I mean, it depends on what type of expert they are. Let's imagine I'm a licensee here with the State Bar, but I also am separately an expert in skid marks, and I can do like accident reconstruction. The fact that I'm doing accident reconstruction expert work is obviously not the practice of law. But if you're really contacting me because you want to know about the standard of care in a legal malpractice case, I'm only going to be at all valuable to you based on my legal expertise. So I can't call someone else that doesn't have that expertise and be, paying them as an expert and have any value.
Right. I mean, I think there is a category of people who are not lawyers who give something that looks really close to legal advice. It might relate to processes or, things like that. Like real estate experts, for example, might walk through the standard, how deeds are recorded or something like that. But yeah, that's something just to keep in mind. Cassidy, you had your hand up. Cassidy, you...
Yeah, sorry, I was on another page. It's okay. The only thing I was thinking about the distinction between consultant and expert is, I mean, is it the way that you are? I mean, because you can hire an attorney as a consultant. Say, like in a family law case, you need to have a bankruptcy attorney to advise about bankruptcy issues in the case itself, and they're consulting on that issue. And they actually serve the role more as like co-counsel. And so it depends on, how that relationship is characterized in the agreement, So is it enough to just say, there's no attorney-client relationship, I'm only being retained as a consultant, and then that takes it out of that whole question of whether or not they're, fundamentally serving as co-counsel on the matter, because then they can be sued for legal malpractice, or can they be sued for legal malpractice?
Yeah, why not?
So I just think there's a significant gray area depending on what they're actually doing, as opposed to how it's just like, contractually set up.
Can I just jump in here for a second? So being the non-attorney and the public member on the committee, I think we have a multitude of challenges with this. One, you have legal counsel or attorneys that are acting as expert witnesses, and then you have non-attorneys that are acting as expert witness in a particular specified area of law. I'll just use myself as an example because I do that. So, I run a human resource consulting firm. I'm an expert in HR.
Right.
So when I am retained to be an expert witness, it is solely on employment law matters because that is where my area of expertise lies upon. And so I am interpreting the law because I'm talking about California law, what the law says you can and you cannot do.
Right.
And then I'm also making the determination based on, did the employer do what they were supposed to do? Did the employee do what they were supposed to do? Based off all of the information, now I'm providing a report. Now, I'm a consultant, but I'm also the owner of my company as well. So when you start saying, is it a practice of law? Is it not a practice of law for non-licensed individuals? Yes, because I am giving my expert testimony based on the law. Now, I am interpreting what the law says, But especially in employment law, I'm literally saying, this is what the law says, this is how either party has violated that particular law. And then I'm drafting my opinion and my report based off of the interpretation of that particular law. Don't know if that adds some clarity to the situation, but I am not going to be retained as an expert for real estate because that is not my area of expertise and I cannot interpret that. But so I think it's kind of, when you're looking at it, it's too many variables to be able to say, like Aaron said, I'm an attorney, but I have expert knowledge on skid marks. That's kind of a fine line. So I'm not sure if you want to, stipulate, okay, where it needs to be a consultant, it needs to be this, that, and the other, because it's, every situation is going to be a little bit different.
I'm going to go to Cassidy next, but just a quick question is if there were an opinion that you got that said sometimes being a consulting expert could be the practice of law depending on what you're doing, and it looked like exactly what you're doing, that would be potentially problematic.
Yeah.
Right. Cassidy?
Yeah, I mean, along those same lines, I mean, what Vikita's saying is like I think if you're just giving an opinion based on a set of facts that's given to you by a lawyer, or you're advising about like a hypothetical that is, that the lawyer is giving to you, you're not practicing law. But once you start actually giving advice about, how to handle a matter, like whether or not you're, that becomes, especially if you're the lawyer consultant, that becomes you're practicing law alongside the lawyer you're consulting. You know what I mean? So I don't know if that is like where you can draw the line between a consultant that's not practicing law, whether you're an attorney or not, versus a consultant lawyer or non-lawyer who is, where there could be, I don't know. Anyway, that's what I was just trying to think, like, because if you're assisting the lawyer in how to handle the matter as they're going, as opposed to being given an assignment, a scope, to give an opinion on whether or not you're testifying.
One of the things that Vikita does is to evaluate the strength of claims, right? Based on her expertise. That's pretty close to advising them on how to handle the matter, no?
Yeah.
100%. That is 100% what happens.
Right, okay.
So, yes. So, whoever's retaining the expert, obviously we know why they're retaining them. So let's just kind of cut to the chase. So yes, you are helping them to be able to make that case. And here's the information that is allowing that. And then they're relying on your expertise in that particular area. For me, employment law, to be able to say, did this person do this, that, and the other? And based off of the information, yes or no? If not, what did they do? And so you are providing legal guidance. I'm going to use that word very loosely. You are providing legal guidance to that particular counsel, whoever has retained your services.
Right.
So yes, you are providing legal.
Are you practicing law?
Vikita's going to say no.
I am absolutely say no. I am not practicing law. I don't practice law, but we
would never. Yeah, I mean.
I'm interpreting law for the client or for the attorney, because oftentimes you will get an attorney that does not specialize in an employment law matter that is handling an employment law case. So they could just be a business attorney. And the majority of the cases, let me just retract that. So you could get some of an attorney that does not specialize in employment law. Maybe it's a corporate attorney or a business attorney, and this is their client, but then they have this employment law matter, and because they don't know employment law, they go get an HR expert to say, hey, help me with this case. And what does this mean? So you are literally interpreting what the law is saying to the attorney that may not be their area of expertise.
Right. And that's okay. I mean, I don't think we're saying that that's controversial, because that does happen. We're just trying, that's not necessarily the practice of law, and there's.
We're not practicing law at all, Cassidy.
That's right.
No, I know. I don't want to get into that. Go down a rabbit hole.
We're not practicing law.
Very clear on the record.
Dual professions.
We're interpreting the law for them, oftentimes, depending upon what it is.
But this is the tension because creating a somewhat different rule. That's why I think the ABA drew the line where they did, because it's very clear and everybody can know this isn't a thing. You don't have to worry about practicing.
Yeah.
Lawyers don't have to question whether they are, depending on how they give their advice, even if it's exactly the same as what somebody else might do. Because you then have a situation where if you're a licensed person and it is the practice of law, you could be sued for malpractice, but a non-licensed person can't be, things like that. Yeah.
Just on that note, one of the public comments that kind of addresses this exact issue indicated that the ABA opinion relies on Model Rule 5.7, which California did not adopt. So that particular comment, I believe it was by the San Diego Bar Association, indicated that if COPRAC was going to come to this conclusion that it is not the practice of law, they would like to see some different authority for that, since the ABA authority is based on a rule that California declined to adopt regarding responsibilities regarding law-related services, is what 5.7 is.
Yeah, I think the response to that would be that the ABA rules that we don't have are persuasive, if not, authoritative. But yeah, that's a good point. And
There's
we
also,
did.
I'm sorry, I didn't mean to cut you off. Go ahead. I was going to say, there's also ethics opinions that are basically in line with the ABA, with the model rule, that could be cited too. That has a big, yeah.
We did
Our
go
ethics.
into, and Rachel pulled up some of the legislative history of why the rulemaking did not include 5.7, and it was basically because they felt like it was covered by other rules already. So I think that would be another response to that. It wasn't that they were necessarily rejecting it, although, like all legislative history, you can draw from it whatever you want, ultimately. Okay, these are the... Eleanor, go ahead. Thank you.
As we're talking, I'm more persuaded that the distinction between testifying and consulting is not going to provide a bright line for us. I think it's really what they're doing. But I'm also thinking about situations when lawyers are neutrals and you're using your expertise in interpreting the law, but you don't have an attorney-client relationship, and it's clear you're not representing any of the parties, and there is no, the obligations are different. You're governed by a different, and while some obligations might apply, it's generally accepted. And I think under the rules, you're not practicing law or you're not representing a party. So these, the duty of loyalty and all of that would not apply. So I think we need to be mindful that lawyers can do things that look a lot like practicing law, where they're leveraging their legal skills and not be found to be representing a party and owe those duties.
Yeah, and so the other thing that I would just put out there for the third point, and this pulls on the other two things, is that the purpose of this opinion is to lay out conflicts analysis for experts. And if an expert is relying on the fact that what they're doing as an expert is not the practice of law, and that the rules then don't apply to them, and so therefore conflicts are not a concern, then they're kind of way off, basically. So that is the focus of this. So it may not have to be definitive about whether this or that exercise or this or that phase of expert work is the practice of law. It could be more focused on the conflict issue and saying it might be, but even if it isn't, you have to consider the conflict's rules. Yeah.
I just would add that I think what Cassidy was saying makes sense. It's not so much how the contract lays out what the scope of services it will be. It's really going to be the actual work that is performed by the attorney with respect to the matter. Because unlike being a neutral where you unequivocally represent no one, generally speaking, I think most of the time when I've seen consultant/expert engagements, it always says it's going to be an opinion that they may or may not like, and that's why it has
right.
the two phases.
Yeah.
But if part of the services as a consultant are actually acting basically like, I think Cassidy had said, almost co-counsel, giving expertise in an area that's necessary to do proper representation, I don't think by using an expert engagement rather than a general attorney engagement is going to protect the lawyer from giving bad advice.
No, but I mean, to the point of this opinion, it certainly doesn't protect you from the conflicts rules.
Oh, yeah.
Right?
Exactly,
And that's
yes.
kind of the point here.
I mean, because you're providing legal services to that client at that point. It's
Right.
not like just their opinion. Because I could envision like close to a trial date, oh my gosh, someone, and it happens, unfortunately, the real expert is for whatever reason not available, and you have to get a substitute. So that late designated expert only is there to testify so that there's someone at trial, and they gave no other services, then perhaps in those kind of circumstances, then they're not practicing law, they're just giving their opinion. But most of the time that I've seen, the person who's designated as an expert is actually part of the team.
It look a lot like an advocate.
Yeah, I think so. Although that would hardly
I
be the
agree.
best way to testify, but yes, I agree.
Unless they come to the wrong conclusion, then they're dropped and there's a different consulting expert who comes in. Yeah. Okay. That's really helpful. Does anybody have other comments about these first two questions that we've been working through? The neutral analogy, I think, is a very good one because that is, at least currently, not the practice of law. And it would be a surprise to neutrals to find out that that was in question. Okay, how about in scenario 3, where it's actually more technically going through the conflict analysis and just concluding more firmly that the duty of loyalty would prevent what I think is true, that you can't serve as an expert when your firm is representing the opposing side. You can't serve as an expert opposing a current client of your firm. And this just had never made sense to me. Something that I don't think any one of us probably would do, or you would just be like yellow flags waving. So what does everybody think about that? Meaning staying it's more strongly like this would be a conflict.
Didn't we review case law that said that there had been cases where screening measures were effective in those situations because the material limitation conflict could be cured with a screen because it wasn't, the concern of the imputation wasn't like confidential information or something like that. It was just the fact that it was a material limitation conflict.
Yeah, I think that probably would be an important distinction to make. I mean, I think that also, like, in the previous draft, we suggested that getting paid in part by those fees would be part of the conflict, but really the imputation rules account for that and say you're not getting paid specifically for this case. You might be getting paid as a partner or associate in the firm, but it's not particular to this case. Then it's okay. Then it's not necessarily imputed. Okay.
And we see that carve out all the time in other areas of the rule where they say like you can't receive any fees from this representation unless it's like pursuant to a partnership agreement or like
Generalized.
Yeah.
Right.
Generally, so.
Yeah. Okay.
But I think that's right, that a screen could be an effective measure. I mean, I'm sure the client's not gonna like it. The client is free to fire.
Why you must take on this expert engagement is not totally clear to me, but if you must, there are remedies, and it may not be per se permissible, but it can be probably relatively clear that in most instances it wouldn't be, without those protections, wouldn't be okay.
I think it's a curable conflict.
Carrie, can you move your mic closer when you talk?
She said she thinks it's a curable conflict. so-
Yeah, sorry, I was saying I think it's a curable conflict. It's not so prejudicial.
Okay. Other questions the working group wants to pose, this is really just getting feedback so that we can go back and do a new draft incorporating these types of changes in here. It's obviously more nuanced, but that's okay.
A question though. I just have one quick question. So you said, well, let me just pose my question this way. What if it is a large firm, but they have multiple locations, multiple offices, and so LA is representing the case, but they're going to pull an expert from Chicago just to be able to, provide expert testimony on this particular matter? Are we saying that that's
is that not conflict?
No, it would be. I mean, the conflict would impute to everyone unless they were in some exception under 1.10. And so it doesn't matter if you're in Dubai, it's the same firm for conflicts purposes.
And then when Carrie's saying it's not, there's curable conflict, is that what you just said?
Yeah, so sometimes firms, especially large firms, are able to implement ethical walls, both on like an informational barrier level and then also on like a personnel level, to ensure that there is no, the imputation concerns are cured by effectively screening these two, the expert from the case team or from the client, to cure the potential conflict.
Are you assuming there would be a waiver as well, or no?
I mean, that's.
I think the screen would probably resolve the imputation, so you wouldn't not have a conflict.
The conflict's coming from the duty of.
Well, usually, yeah, it's not usually how the rules apply. If we find there's a conflict, then I think you have imputation, and then you go to the rules on imputation, right?
That goes back to the first question, which is the lawyer providing, is the testifying expert providing legal services? Because if not, then they're not adverse to a current client because they're not providing legal services. So we don't.
I see. So you're only addressing whether or not you can cure the imputation, the having of the confidential information creating a conflict, not whether or not there's ethical. Got it.
Well, because there is, you cannot be on both sides of the same litigation. That's prohibited by the rules. And so if we're going to say that the testifying expert is practicing law, then now you've got two sides of the same, on both sides of the same litigation. And so then we're grappling with how do you cure that potential issue?
Yeah. So Allison.
I was gonna say, isn't the duty of loyalty bigger though? Like, it's not just practicing law. And I think that's what's being said in some of these opinions from other bar associations. So just putting yourself out there as an expert against what your client needs, right? Even though you're in two different cases, is a slight conflict of the duty of loyalty. I agree with you that it can be curable, but I think the waiver is actually important here.
But that's a position. I think you're referencing a positional conflict, which is a little bit like you are allowed to advocate in one case before a different tribunal a position that's inconsistent with one of your other client's causes, as long as it's not like the same case in the same tribunal. But you can take inconsistent positions in different cases.
Right. No, I understand that. I'm just.
To your question, I think I drafted scenario 3, the revised version. So I did interpret the duty of loyalty to be broader than the conflict question, and to suggest that you wouldn't do it. Doesn't really matter if it's practice of law or if these rules apply if you're a non-lawyer. I mean, or if you are a lawyer, the duty of loyalty would basically prohibit this.
I think that's where we were landing during our call, right? That was the one area where folks tend to agree.
Right. Novella.
Yeah, I just had trouble understanding part of the hypo. So with the track changes that added, the company has no connection with the matter. And then like a little bit above that, it says the testimony is adverse to the company. So I was like, what? I didn't understand how those were both true.
Sorry, do it again, one more time.
Yeah, I was trying to just think of to help understand how the rules were being applied. Like what would be a situation where the testimony is adverse to the company, and with the track changes, it says the company has no connection to the matter in which the expert is testifying. So that just made me unclear of like what's happening. Does this happen in real life?
Right, okay.
We're looking at this.
Got it.
Correct.
Yeah, so I think that's a revision that came from some of the comments, but I think that what it's saying is that it's not, obviously it's not in the same matter, right? Is that the revision? I'm not familiar with this revision, but. So
Rachel?
Let's see. So that's where the expert is going to be adverse to a current client, but in a matter where the
Unrelated matter.
The firm's not representing the client in that matter, and it's unrelated to the subject matter of the representation.
Right.
Yeah.
Right.
So this red line here was a suggestion from one of the public comments we got to clarify this scenario.
Okay. So it's not that the expert's on the other side of the same matter, if that helps, Novella. Is that what you're talking about?
I think the company should say the firm. That's of course the company has a connection to the matter.
Right.
In which the expert's acting, but that should say the firm, the law firm.
Yeah.
I think it's just a typo.
Yeah, that's what was confusing.
I think that's right. Does that make more sense if we said the firm has no connection with the matter in which expert is? Okay.
Yeah.
Okay,
For consistency, it should say law firm.
Yeah. Okay. Other questions or comments about these issues? It's obviously heavy lifting when you talk about the scope of conflicts, the practice of law, the not practice of law. It's not. Vikita's being very clear about this, actually. When she does it, it's not. But that's right.
The non-practice of law.
Exactly, you're right.
Make sure that is highly documented in the record.
Should we just put your name in a footnote and
I didn't
just
put my name
have
in
it safe harbor for you?
But
I go for employment law.
That's right.
Advice.
Carve an exception out.
I will point out, though, that most malpractice insurance providers do cover when an attorney from the firm is providing expert services. It does typically fall under the coverage of most malpractice insurance policies. So that's sort of an interesting practical note.
Yeah, it's interesting, yeah. Okay, the working group has gotten a lot out of this. So does anybody else have other comments? And we'll move on to the other one. But thanks. This is just an example of where we thought through it, but decided to come back and sort of group think a little more on these items, and it was very helpful, I think. Not that we're any closer to a resolution, but it's okay. Anything else on this? Okay.
So
Raquel?
what's the next step of the working group?
We're going to revise this, and it's going to be a revision in light of the public comments on these 3 points, and then the committee will see it again. And if it's substantively different, it might need to go out again. And if not, it won't, but it probably will. Okay. Let's go ahead to the next one on the agenda, which is flat fees and termination, and it is Raquel and Aaron Joyce.
Yes, and Rachel at some point is going to put it on the screen. I'll start out, Aaron, and then turn it over to you. The action of the committee we're looking for ultimately is to be able to vote it out. Either if you think the changes are substantive enough that it needs to go out for public comment again, which we think it does, or if you all think it doesn't, then on to the finalization of the opinion. As you may recall last time, that in the only area that we worked on based on the feedback from the committee was what we have now called practical guidance. You last saw it, it was best practices, which we got some feedback from the committee on, and we also landed on the side. We wanted to include this section because it was felt that the more guidance we could give the attorneys on how to deal with something that they're just beginning to switch to, in a more broader way would be important, but we also didn't want to call them best practices because then maybe attorneys will say, oh, if we do these things, then we're fine and we don't have to worry about it. And we realized we weren't trying to pre-chew what they should do to that level of distinction, but enough to put in maybe a big enough fill that ultimately would simply say, you should really think about this deliberately, and here's some things you should consider. So that's the spirit of what you see. And so Emil and myself, between now and the last time, and I think what we did when we got together really was just kind of work it up as we were just typing. And so the statements, if you go up a little, Rachel. Yes, oh, you got it on. Can you put those 2 lines on the second page so we can look at everything on one page? You just scroll down, yeah, thanks. So basically what Emil has and what I have on the right side, and I can just read mine because it's a little bit longer, is basically the same thing with a little bit more punch to it, which basically is just trying to acknowledge this is guidance. Every client is going to be a little bit different. But at the same time, we think these kinds of ideas should be thought about, should be clearly communicated upfront, and that attorneys who offer this should be mindful. And we just provided examples. So that's basically the net of what it said. Unfortunately, this was not attached to the agenda, so you haven't had a chance to read it. And so the original statement that was at the top is just not as explanatory, that would be the word, as the one I was adding. And then if you can scroll up, Rachel. I'm sorry, down. All right. So on the second bullet, which is the same as what you saw last time, we just added the idea of just making sure we're saying flat fee agreement, just again for trying to be clear. And then the idea, another bullet which ties to the bullet that was on there, which is just, again, specify if there's other services that are included, and if it's not, say any other thing outside, what it would be, how you're going to bill, and get something in writing. No surprises. So that's the other one. And then specify the milestones, which we had a lot of dialogue with Erin adding her experience, to say, well, there's kind of a number of ways you can have a methodology to determine what the milestone is. It could be, if I do X, I get this money now. If I, if I file this document A, I get 5,000, or if I file this document, I get 25%. So I think Erin said, hey, there's different ways to do that. And then the idea was to guidance again, choose one methodology for your whole agreement. Don't say document A is 5,000 and then it's 25% for that. Again, it can work out and the lawyer can probably calculate that easier than the client because it can get confusing. So just, again, guidance. And then the idea that you should track your attorney time and everything, because even though it's a flat fee, if you end up realizing that what I said was going to be included, this is now turned into something very different, then you have to be able to have some, what's the word I'm looking for? Can't think of the word, but another word, something that is legitimate, a legitimate way to say, this is now what you're going to owe me based on what I've done. And we then talked about the idea that quantum merit can be part of the conversation. And then the last bullet was unchanged, which is again, just set your clear goals, your timelines, how you're going to communicate with the client, primarily around these milestones and the money and time and all of that. So that in some way, at the time of signing the agreement, the attorney and the client is very clear how this is going to work and what is going to trigger this agreement changing into something else, and how much you're going to anticipate paying and the billing cycle and all of that, so that people don't, as a client or even as an attorney, haven't thought this out and it gets triggered and then you're kind of making stuff up, which will undoubtedly create conflicts between the client and the attorney. So that's sort of the net of what we have here from last time, which is just more clarity, the benefit of having Aaron in our group to help us pressure test some of the thoughts that we had about maybe conceptually how it works, and then how someone who does flat fee billing more regularly, how it actually can play out the pros and cons of it. And I'll turn it to you, Aaron.
Yes, I appreciate that. I think what we talked about it, and the problems and pitfalls of doing flat fee.
Turn your mic on.
So sorry, I keep forgetting that. Thank you for that, overview. We talked about, since a flat fee is not earned until full performance, there has to be some kind of metric for determining how much of that flat fee may have been earned if the work wasn't completed. And what are the duties to account in the circumstances where where the complete services were not performed? And especially, honestly, since this adoption of the current rules of 1.15 and many lawyers that do flat fees not putting those funds in a trust account for many good reasons, how do you also deal with that issue and the fact that, especially, let's say, in an immigration practice, even though it'd be a flat fee with different milestones along the way, the life of the case, like $1,500 at application, another $1,500 or whatever amount at interview. Meanwhile, that client didn't come in with $1,500. That client came in with the $250, and they were going to be making monthly payments toward that flat fee all the way along. So we talked about, how do you do that quantification? And the two that are referenced earlier in the opinion, which are not exclusive at all, they're just different parts of the same coin. One is having milestones. Instead of saying, in like a criminal case, $10,000 for the prelim, having milestones to get to the prelim, because once you pass a milestone, guess what? That part of the flat fee is fully earned. No more issues. Then whatever's left in between that and the performance, that's what the quantum merit analysis would be later. And the truth is, if you're going to have to be potentially doing quantum merit analysis, it makes sense to keep time, especially when there are so many commercially available timekeeping systems now that are not the kind of painful situation it was even 5 or 10 years ago. It makes it so much easier to quantify and to account for monies if you are in a situation where you didn't complete the services.
There is a tension out there, though, between some of these authorities that say that flat fees are not about an hourly equivalent, right? And they're not supposed to be just measured by default to that, because you could say, if I charge you a flat fee based on developed expertise and it only takes me 4 hours to do something, and then you come back and dispute it because it's not reasonable as the hourly equivalent, but you got this flat fee worth of value. So I think it's okay as an alternative, but I don't think the flat fee value should be stated always in the context of an hourly fee alternative. It makes sense. There's nothing else you can come up with if you don't have clear milestones. So as long as it's put out there as an alternative, I think that would be okay. But the flat fees are not supposed to be determined by hourly rate equivalents. They're something else. It represents different amounts of value.
Oh, no, I agree with that.
Okay.
And that's when we did talk a lot during our meeting, our working group, about the tension about, if there, a circumstance is that the scope of the services either wildly increases, or, I mean, we thought 5 minutes and it ends up being 5 hours, or worse.
Yeah.
What are the, the renegotiation and all those issues that come with that? Because it has to be a fair deal for both sides, otherwise, you're not gonna have the best, quality legal services being provided. So I do not think, and also you have to be able to properly evaluate how much should this cost if it's a typical type of case.
Right.
So, yes, those were the kind of issues. And that's why we put in this idea of practical guidance about you may still want to consider, even if you're doing flat fee work, to keep your time. It'll also help you better quantify later on for the next case how much it's going to cost, so you know if you're actually making money or not that way. And also having the milestones, instead of just having one flat fee, having multiple flat fees. It's basically a series of flat fees along the life of the case.
Right. That is definitely, I think, the best way to do it. It's rare, but it is the best way to do it. So I have a threshold question just for staff. One is, would the revision of practical guidance like this constitute a substantive change that needs to go back out for public comment?
This last returned from public comment in January of this year, and this is the second series of edits that we have made to this opinion since it last went out for public comment. So I think given not only the additions of the practical guidance, but there were some other areas of the opinion that were kind of tweaked and solidified and conclusions made more clear. I think that at this point, we probably do need to send it out for another round of public comment.
Okay, so the second question is, because it wasn't included in the materials for today, should we give everybody a chance to read this more carefully and then approve it at our next meeting? Or is that not necessary?
That would be my preference, because just looking at what I have right now, it doesn't look completely finalized. It looks like some things still need to be incorporated or in comments deleted and
Okay.
things of that nature.
Does the working group want to present a draft that we can circulate for the next meeting?
Nima will turn over on the airplane. So is there, here's what we were thinking. We've given you enough of a frame in the words to be able to say, okay, yeah, working group, you'll work with staff, and then you send it out. In other words, we're not gonna change it. If you look at what's there in yellow, right hand and left hand, it's from the same body.
Okay.
It's just a matter of smoothing it out, a word here, a sentence in or out. So that would be what we would prefer versus holding it.
So staff revisions that would just clean up the draft according to the...
In the practical guidance area
Right.
only. Everything else has already been accepted.
Yeah, that's fine. Staff can work with the working group to clean that up, and then
Yep,
yeah,
okay.
that would
So, yeah, if you would, Nima he's the lead, I think, drafter. So
Okay, so
if we could get that support, that would be helpful.
Thank you.
We're looking for a motion to send this out for public comment?
I'll move to send it out for public comment.
For our own thing, yes, I moved that we can move this out of committee and get it back out for public comment.
With staff's help.
With staff, like revising and smoothing it out for circulation.
And Raquel seconds. Okay, let's vote on that.
Okay. Ali? Brown?
Yes.
Coleman?
Yes.
Guzman? Joyce?
Yes.
Mad Watkins?
Yes.
Mercado?
Yes.
Mohebi? Perlman?
Yes.
Poindexter? Riley?
Yes.
O'Reilly?
Yes.
Are we
Hold
not
on,
going
O
alphabetical?
comes before
I know,
R.
are we not going in alphabetical order anymore?
The chair goes last.
Oh, I see. Oh, that makes more
That was
sense.
the confusion because he was always before me, so that's why I was
Right.
confused this meeting. Okay, thank you.
We're waiting to go in order.
All right, we're
Okay.
clear.
With 9 yeses, the motion carries.
Okay, thank you.
Sorry, I should have raised this earlier, just a point of clarification. I know we discussed this at the last meeting in terms of timelines and how long we'd like to issue it for public comment.
Mm-hmm.
I think given that this has gone out multiple times, I think a shorter period would be okay, given there are some substantive edits, but it's pretty localized to that one section. How long did the committee want to send it out for?
What's the shortest option?
I believe we can do 30 days. Let me check.
Probably 45.
Because the way that different committees have their calendars, I think if you have 30 days, it's not really effective.
They
So I
might
think
not even
45
have a
days.
meeting in that interim.
Yeah.
Yeah.
I think 45 days.
Okay.
That will get it back for December meeting or January?
December 5th is the December meeting, so
Too early, a little too early.
just, yeah.
35.
Okay, let's go to the next one. Draft 20-0005, conversion clauses in contingency fee agreements. This sounds so vaguely familiar. And
Wonder
this is
why.
Eleanor. Eleanor, the floor is yours.
Thank you. I won't keep it long. So the
Yeah.
working group got together and we reviewed the draft. There was some debate about whether or not we wanted to revert back to the hotliner, to be candid, but what we've decided to do is continue with the existing draft, and we'll bring it back at the next meeting with a recommendation on whether or not to go toward a hotliner. If we all are in strong consensus about the hotliner when we next meet after the draft takes shape, we'll bring a draft as well, because I had already started working on one, so I don't think it'll be hard for us to get both before the committee. So I think the short answer is we'll be back, put us on the next agenda, and we should be able to have something to you then. But we're still, I don't want to speak for the entire committee, but my sense is we're leaning more toward an alert now than actually going with an opinion. So
Well,
Cassidy, do you have anything to add to that?
No, I think that's correct. I think during the working group meeting, I raised all kinds of revisions or questions, and then I took on the onus of revising, and then, I forgot that I had. Yeah, thanks.
The one other thing I will say that could be useful, and Nima recommended this, was that if someone who is on the flat fee group would like to join us, we'd like somebody with experience with fee work. If anyone does want to join, if there's a lawyer that has experience with fee work, I think Nima was seeing some overlaps in the issues we were wrestling with and thought it might be useful to get another view from that group. So I'll put that out there if anyone's interested. If not, we're okay proceeding as is.
Well, since the flat fee is ready to be pushed out, I'm happy to help with that because I have a lot of clients that have issues with this area.
I think we'd welcome that. Thank you very much.
Yeah, thanks, Erin. That'd be great.
Okay, and adding Erin to that working group, and we will look for something from you in December 5th.
Great. And staff, could we ask you to send Erin the last email? I think that included all of the materials, but if you could forward that to Erin so she has the background, that would be terrific.
Yes, no problem.
Thank you.
All right, thank you. Next item is draft 21-0007, cryptocurrency. And this is also Eleanor.
That's me again. So we also met on this one. This one was on pause for this meeting so that the new members were here because we need more people to join. So if we have any volunteers, we'd like to get at least one more person and two ideally. So if anyone's interested in the topic of crypto, This is another one that's leaning toward potentially being a hotliner, largely because there's so much uncertainty in this area. And the original opinion that was drafted dealt primarily with like Bitcoin. And there questions have come up about the scope of the opinion and about whether or not it's wise to put an opinion out in this landscape where all the regulation is so uncertain. So I think we're leaning toward an advisory, but we'd really like to get another person or two to join the group.
Okay, well, Adam was out of the room when you made the request, so he's obviously the candidate.
All right. Welcome.
We're looking for another working group member on cryptocurrency, but apparently that's not the same as Bitcoin. So if you know that those things are different, then you should probably join this.
I would join.
Okay, Allison.
Perfect.
Need a young person, not an old person.
And then staff, I'd make the same request. If you could send Allison the last draft.
We'll find out how.
It's not changed. And then we'll make sure that she's included in the next working group meeting.
Okay.
We'll do that as well.
So when you come back in December, you're going to say it's going to be a hotliner or an opinion, and we're going to do something?
That's correct.
Okay. We'll be looking for that in December.
Yeah.
Thank you. The next one is the draft topics, processes, and format for guidance. And the working group is Cassidy, Eleanor, Nima, Vikita, and me. And we established a revised version, we circulated a revised version of these internal protocols for timing and selecting and bringing in a reference to our committee rules and just giving some more structure to the working groups. So I revised this and I originally drafted it, so I'm going to open this up to others to discuss, but Cassidy, you can take the lead on that. You can just ask other people for what they think about these things if that's where we want to
Wait,
start.
I'm sorry, I missed that. What are you asking me to do?
If you want to, you can just maybe start with, I think these are your changes from last month, the adding an editor function.
Oh.
And so the revised version that went out was changes from the original draft, which was circulated last month. So it's really just a discussion of the most recent changes, but also the document as a whole in terms of internal guidance, including the timeline, which is now significantly different. Do you want to talk about the changes you recommended?
I don't remember. Did I make these? I don't think I made these changes. I thought you made the changes, Dan. This is the working.
After you sent me an email about it, but okay. The editor, adding the editor.
Yeah, I do remember that. I'm so sorry. Hold
Remember
on.
when we collaborated on this together and we came up with this great idea?
Yeah, I did. But I think we talked about, so I have Nima's changes, right?
Yeah.
All
right. Well, while you check that out, I'll just present it and say the goal is to establish internal protocols that set both a timeline and some more structure for a working group that would include a lead drafter, an editor, and a scheduler, so that there's some more involvement of everybody who's on a working group. And the idea is also to set a deadline structure so that people on the working group know if we're starting an opinion, say today, and we're working through what is the expected timeline for having an outline and milestones really for deliverables, taking into account our meeting schedule, which is not always every month. Sometimes it has longer intervals between them. And so it sets out, just again, guidelines for a working group to set some roles, but also meet some deadlines. And if you were looking at this starting now, that would sketch out when you should come back to us with an outline, when you should come back to us with a draft opinion, and roughly our goal toward getting it out for public comment, primarily to avoid circumstances where things don't hit meetings that we're in and get approved for certain benchmarks, which sometimes just makes them drag on into multiple years and and further and beyond that. So that's the context for these. And the most recent version has revisions that the working group made, both NEMA's and a couple of Cassidy comments. And then we combined the issue outline and the opinion outline into one outline. The idea behind that is that when you come back with an outline, if there's an off-ramp where we would make it a hotliner or an ethics alert, that's where we would identify that. Instead of coming back with a fully formed opinion that we then said, let's throw this out and just make it an ethics alert. Thoughts on that? Raquel?
I have a lot of thoughts, so focus me on what you are looking for feedback specifically at this point.
How about the working group structure with different roles?
Okay.
Start there.
All right. Let me ask another question that was not clear to me, and I will answer the working group structure as well. How, in agreeing to adopt some of these recommendations, is COPRAC now bound by this forevermore, and how does it get changed? Or is this like a gentle committee person's handshake? In other words, we're not obligated to do the things that it says here, or so how much is flexible, how much is fixed?
I think the intent is that these guidelines for us internally could be revised and they won't always be met. But it also is designed to comply with our committee rules, which are not changeable by us, obviously. So these could be modified, and then it's guidance so that somebody who's on a working group could say, when should I come back and what should I come back with and what would the timing look like, as opposed to having it be blank, which right now it's somewhat more open-ended about that. But also to make different roles in the working group so that other people have a particular sort of role in it to, so I think the answer to your question is it would be modifiable by us, or in some instances, if we didn't meet it,
okay,
it would be adaptable because it's consistent with the committee rules and it's our own sort of expectations.
Okay, thanks. So overall, I mean, I appreciate the work that the working group has done. And I come to it as someone who has not ever drafted an opinion or any documents in this group. So I've had a lot of chance to participate and to observe. And so my comments are in the spirit of that, which is in some way, some of what we're adding, the structure of it, existed, but we actually have not been very faithful to doing in the past. In other words, we've said we should have a draft outline come as the first step, but I've been on the committee, Dan and I came on the same time, maybe this is my third or fourth year, and I don't think I've ever seen an outline. And I think those kinds of things are important and it will help us move, but I also think we all have the best intentions and goodwill. But I think we're the biggest inhibitor to our progress. And so I don't think any number of rules or structure is going to change that. I think that if we commit and we say we're going to do something, we either do it or we say, guys, I can't do it anymore. And I think we just need to get better at doing that. Because I don't think giving somebody a job of scheduler is very helpful. It's a thankless job. Because the person who doesn't do what they're supposed to do, what is that person going to really do? Except bug the heck out of somebody. And that's just not, like, we don't need that. So in terms of the roles, I am not in support of putting roles, sort of prescribing in the working group specific roles, because in all the working groups I've worked in, they work differently. There's a different flow to each group. And so I don't think we want to get down to the level of trying to prescribe how working groups work. I don't think that's going to be as productive as we think. And I think the structure that, if we were to go in that direction, some of my concern is that we're fragmenting work, and I can see it's going to dilute, it has the potential to dilute the robustness of our work, because we're going to be saying like, okay, you do this piece and you do this piece, and when it comes back together, and I've been in committees that have tried that, you have a different tone, you have a different writing style, so you think you're making progress, but the person who actually ends up leading is like, this is, thanks, and then they have to go and do it. So I just think, and I can see a lot of email back and forth, and I just think like our work would not be strong. So I'm okay if we said considerations that working groups could think about for roles, but I would not say, I would not like that at all, really. But if the committee was like, well, we really want to put some structure around that sort of considerations, but I think it's, the most effective is having the outline first, getting the input from the committee, then bringing back the draft, and having a real cadence, having the documents attached to the agenda. If it's not attached to the agenda, it doesn't come on the calendar. If people haven't read it, be open to say, I haven't read it, don't bring it here, and people don't really know what's going on. I think that, and we just gotta trust each other that we can say, I didn't read it and I'm not ready to talk about it, because we're just kidding ourselves. So to me, it's more our EQ with saying, here's where we are, here's who we are, and that I think, and try to do not the drafting specifically, but as much input and work in some way in the meeting, because what we find out is people don't have a lot of time outside of the meeting. And so when we rely too much on outside of the meeting, we find ourselves not making the kind of progress. But I think everyone has a, good intention. So, long answer to your thing, but I think it's context. Again, I'm not writing, so I can only imagine if I was trying to write some of the stuff, the challenges of it without following the structure that we established for ourselves, which is bring the outline. It's 12 of us. It's not just you writing it, and don't get so attached to you leading on an outline. I will also say, I think we should consider whether the chair and the vice chair should be leading on some of this work, because I think we only see what happens in this room, but they have a lot of other committee work. And I think my impression is that the chairs and the vice chairs of the committee have overly been leading opinions, and that has been a challenge to moving work forward as well. And I'm over.
Okay. Just for context on the working group, the intent of signing roles in a working group would be to take some of the pressure off of the lead drafter, because the current default is basically that the lead drafter is responsible for everything. And when you're waiting for whoever the lead drafter is to do it, it depends on their schedule, but also they're sort of doing every piece of it versus having them do a rough draft and have an editor refine it, and then having a scheduler say, hey, if you can't do this, let me take a piece of it and give it to somebody else. So that might mean that there are disjointed aspects to it, but a lot of our opinions are drafted by committee, literally, anyway. So that was actually the intent, is that one of the sort of pressure points is that a lead drafter becomes the sole person who's responsible for deliverables in a working group. And that's really difficult.
Yes, amen.
Right? And that's really difficult. It leads to a lot of lag time, because if you happen not to have time to do everything, then it's not going to happen. So the idea was to disperse that among some different roles, that we would be able to say, okay, the scheduler notices that you haven't done this by this point. Maybe then we can hand a part of it off to somebody else in the working group and have it be everybody pulling an oar, essentially. That's the intent. Yeah, Allison?
Can't we just say that? No, but instead of assigning roles, that working group members will edit and are responsible to, for different parts of drafting to be, divided up by the group itself.
You'd think that would be easier.
But
But yeah, I mean, you know, I think we should try the role, the defining roles approach. If it doesn't work, we can scrap it, right? But because, my experience on this committee for the last 5 years, 4 years, however long I've been on this committee, is that the lead drafter takes on most, 80% of the work. So, we are just trying to come up with a system to avoid that and make it more productive.
Yeah, it's
and
not
collaborative.
meant to limit anyone's role or minimize anybody's role. Obviously, the working groups will work differently, but the idea is just to allow the lead drafter to basically appoint people to support them, and so that there's an expectation that other people are going to step up and support. And maybe over time that won't be necessary, but I agree it's something I think would be helpful.
Sorry, Raquel.
Question of staff and then a question of Carrie. Rachel, particularly, at some point, and I think you said at a meeting when you first came on, and I know Erica was trying to move in this direction, that staff was contemplating taking a more active role in writing some of these opinions and alerts, which I think was enthusiastically welcomed by the committee. So I'm wondering how, is that still an option given, what your staff personnel? And how should we, if it is, that's a release valve for some of what Cassidy and Eleanor are saying in terms of the lead person ends up, having to write a lot. And then the question to Carrie is, my observation is that the documents that Carrie you've led on have seemed, I haven't ever been in a group with you, but it seems like you all stay on the time frame. You come back, like they don't last a year to get to. And so I'm wondering, what's the magic in how you're leading the things that you're leading? Because I sort of just, it's a mental note. I'm like, well, when it goes to Carrie, it's going to come back and we're going to vote.
We can't all be Carrie, okay?
No, but I think maybe there's some learning, some lessons, some things that because if I was in her group, I know, but I haven't been in her group, but I just observed that.
Well, I sit in a group with Carrie, and Carrie is the individual that will just, if she says, I'm going to get this done, and this is just my observation, she gets it done so she can get off her plate, so she can move on to the next thing.
I just push things onto other people's plates constantly.
So that's how we end up, okay.
No, and I think really the only thing that I've been responsible for moving was also with Eleanor and with Nikita, and I think we all just were highly motivated to get the 7.3. I think it was something we were all really passionate about, and so I think that being staffed on matters that you care about probably also helps.
And to address your question, before I answer that, I just want to, for the new members and anyone that wasn't here last time, I believe it was at the last meeting where we decided that staff would automatically be incorporating public comment when things come back without being asked. So we will just do that and send it up to the working groups for you guys to review. So that's going to be part of kind of streamlining this process. So we're going to be doing that moving forward. And then, yes, staff is available to assist with drafting. I will just note that there is one opinion, I forget which one it is, that there is an outline that's going to be worked on, and then staff was going to draft that, and we haven't received the outline, so staff hasn't been able to draft it. That's been, I think, going on for a couple of months. And then, obviously, the DA ethics alert, which staff also drafted, there are issues with that. So I think if staff is going to be involved in the drafting process, we would just need a lot more guidance from COPRAC in terms of what you are asking of us in order to best utilize our time so that we don't spend time drafting something that COPRAC is like, this isn't what we envisioned, we need to completely start over. So I think if we get those detailed outlines, then staff can better able assist.
That's what I do think that is a critical step with staff involvement is the detailed outline phase. And the idea is that you come back at the first phase with a detailed outline for the whole thing. Then the committee says, add this, add that, take this away, also reduce it to, an opinion that's like a reasonable amount, but also to say this should be a hotliner, or this should be an ethics opinion or something else. And then when it goes to staff after that first meeting where we consider the outline, everybody's also invested. And so the committee has already put in its 2 cents, and you have ideally a much clearer picture from the discussion about what should be the first draft. But it would be great if that was the first step after the detailed outline, because I think that would help a lot.
Rachel, would it be helpful if staff is going to draft opinion or alert to be in the working group meeting, to be part of that? Would that be helpful?
Yeah, I think that would be helpful, so that we can kind of get a heads up and know kind of what the issues are and what's being discussed. I think ultimately the COPRAC exists to create and develop these opinions, and obviously staff is available and we'd like to help out, but I think that probably should be the exception rather than the rule, with staff drafting, for example, a first go at an ethics opinion. I think maybe the alerts and the advisories, kind of the smaller, more discrete tasks, probably would be better suited for staff to do. But like I said, I know we have one slated, for an example. We have an opinion slated where staff will be taking the first stab at drafting that.
Okay, if that goes well, watch out. Kathy, did you have a comment? I thought you might have had a comment earlier. Did you have a comment?
No, I think Rachel covered everything. Staff is really willing to assist. And, we are, as we transition and we have new committee members, there's always there's some bumps in the road, but I think we will get everything in line. And considering that COPRAC has to have a work plan next year, I think it's really incumbent upon our committee members to, keep that in mind as we move towards our work plan and what we can actually accomplish outside of our meetings.
Great, thank you. Okay, the other comments on this topics, processes, and format for guidance. Anybody else want to raise an issue? The goal is to vote to establish these, I guess, to adopt this as our format for guidance, which can and would be updated as we need to or want to. Because again, it's consistent with the committee rules and it's an internal protocol for just how we're going to keep things moving forward. So if anybody has reached a point where they're ready to move to adopt that as revised.
I'll move to adopt it as revised and just remind the committee, I mean, I appreciate the concerns that were raised, but it's not binding. Groups can work differently, but I think it's intended to empower whomever is the lead to get some support.
Okay. Eleanor moves to adopt that document as revised. Any second for that?
I'll second.
Carrie seconded. Shall we vote?
Okay. Ali? Brown?
No.
Coleman?
Yes.
Guzman? Joyce?
Yes.
Mad Watkins?
Yes.
Mercado?
Yes.
Mohebi? Perlman?
Yes.
Poindexter?
Yes.
Riley?
Yes.
O'Reilly?
Yes.
Okay. 8 yeses, the motion carries.
I wasn't ready for a vote, that's why I said no.
Okay.
When I looked at the timeline, I think some of the increments are too short, they're too aggressive. For example, the issues, the working group circulate, they're outlining the working group November 5th. And then November 12th is their deadline, that's 7 days. Then submit it in the next 9 days or 2 days after the working group submitted to staff. I think those I think we're starting off with the expectation to do things I don't think we're going to do. So I'm looking at page 4. And so I understand it's the spirit, but the spirit is a timeline that we're not going to, I don't see us being able to do that, work this closely. And I just used one of them. There's some other dates as you go down. And so I know we want to be responsive and, as Kathy said, be mindful of the work plan, but also be mindful of what we can really accomplish. And I feel like we won't do it, so.
Yeah, at least from the working group's perspective, the concept was putting this up here and then having it be the working group's scheduler to keep track of what they were able to meet and didn't meet, so that it's a kind of a living document, and then we'll revise it to say you need more time to do this because nobody can meet these deadlines, or this is actually done more quickly, and so in a periodic basis, we should bring this up and revise it based on what the working group experience actually is. But it's a start to sort of lay out milestones that match up to our meetings, essentially. But I mean, that's a very good point. It's probable that in the first period of time, the working groups will come back and say, like, this is off and that's off, and every single one of them is off in some way, and we will just revise it. That's my thinking.
Yeah, and the other thing too is that this initially came to fruition for the simple fact that when we were doing our, and I don't, can't remember what the term is, but at the beginning of the year, there was a document that was circulated that says we needed to accomplish all of this by this time period, right? And so as we have come to September, I think it was like, okay, well, where are we? So that was the basis of the reason why this got started, to say things are just trailing over month after month and year after year. So we have got to get this a little bit more streamlined, be a little bit more proactive, put some hard target dates on here so that even if we don't meet the exact date, but it needs to be tracked so that, these opinions are not going for years and years and years. So that was the original focus on being able to do that, to do something different, because the way things have been set up are not working to be consistent.
That's right. And that was where we started, because the committee as a whole was, I'm being correctly identifying that without any structure, it's just kind of lagging. And
Yeah.
yeah, go ahead, Eleanor.
Oh, I'm sorry. I thought you'd pause there, but I agree. It wasn't as efficient as it could be, and I think this is to set targets.
If these are off, we will revise them based on working group people coming back and saying, like, this is too tight, we can't do it, or we don't need this much time to do it, or everybody agrees that it could be something else, but at least there'll be some real data coming back. And at a minimum, what the timeline does is establish what you're supposed to be doing right now in between the meetings. For this to happen in a year, you need to be here generally by this point. And so the hope is that we'll start to keep, when we're all on working groups, there is no timeline. We're just like, well, we'll see what happens, So that's the hope. But it is a living thing, and it's an internal document that we can revise with the same goal in mind that you just described.
I think for the new members, one of the reasons to push for this efficiency is because people roll off, and some of these opinions that have carried over and had new people come on to the working groups, and you get differences of opinions, and the delay can be, it can be long. And we have a lot of opinions that fall into that category now, and some of them are going to probably end up as hotliners, but I think if there had been more push to meet a deadline, we would have either had an opinion out, or would the idea that we couldn't reach consensus would have been surfaced sooner, and the hotliner could have been put out sooner. So we're hoping this will just reduce that inefficiency of opinions and topics carrying on over years with different working groups.
Yeah, that was happening routinely. And when you inherit something that somebody else drafted and is now gone, you're trying to piece together the rationale for things they did or didn't do, and that's really very difficult to do. It just takes a lot longer. The expert opinion is an example. That's 2000. This is probably the fourth generation of working groups that have been on that, and it makes it a lot harder to pick it up from scratch and say, this doesn't make sense, and I have no idea why they drafted it this way. So,
and I think the positions, for lack of a better term, like the scheduler and this, that, and the other, is just to be, but I think it's more than just taking some of the relief off the individual that is drafting the document, because the individual that has signed up to draft a document, that's what they signed up for. But I think it also keeps the committee organized to be able to track all the data, who's doing what, who's communicating other than the person drafting it, to allow the person that's drafting it to focus on that. And then we can communicate the status of, this is where it's at, this is what's needed, to yourself and to Rachel as well. So I just think that it just makes more sense to kind of have a running timeline with other folks on the committee doing some other things other than just the person that's drafting it, so that we can keep this process moving ahead.
Right. Okay, so Raquel had an idea that I want to just bring up and put out here for the schedulers and the working groups once those folks are designated, which is to identify before each meeting period a meeting time for the working group, so that you don't have to start from scratch and start emailing around when is everybody available. Like, pick a day and time or put it on your schedule when the working group is going to meet, when it needs to meet about whatever it is, so that you don't have to try to spend 25 emails just clearing for people's schedules, which is not very easy to do, or have staff do that. Because, a major impediment for the last period, which is a tight turnaround between two monthly meetings, is just trying to schedule a working group meeting at a time when it actually works. And so, the idea is that if you make a standing meeting for your working group, then everybody will block that time off and be available for it without having to have a specific every time start from scratch scheduling exercise. So I would recommend and hope that the schedulers would do that as one of the first things. What is a day and time that we can meet that works, be in each period, and then match it up to what things you have to deliver? Because that right now is a major hurdle to me, I think. Okay. Other thoughts about this? Let's take a break before we go to the next item, which is the 25 work plan. And apropos of what we've been talking about, somehow the 26 work plan is also on the agenda as well. We haven't even finalized the 25 plan. We've been lapped by our own work plans. I object to that, so just put it on the record. A 10 minutes or 10-minute break? Let's do it. Goal of this discussion is to get updates on anything that was not discussed today. Obviously, we will update the items that were discussed today with those new details. So we're going to put it up on the screen and just touch on hopefully a limited number of things that we haven't yet updated, and then get this done and up and out so that we can move on.
I have been updating this as we've been going through the agenda, so I'm just checking to see if there's anything that says October that doesn't have anything next to it.
Okay. While you're doing that, I would suggest that we defer the discussion of the 26 plan to the December meeting, because that's not due to be submitted until February, and we will probably have new things to add to that. You want to make a motion? if there's, we'll come to that, but I think that makes sense.
So it looks like 24-0001 Ethics of In-House Counsel, former client's IP. Does anyone have any update on that? This is on page 9 of the work plan. Staff had emailed the working group to coordinate to see what the next steps were, and I don't think we heard back. Yeah, we didn't hear back from this working group, so if anyone here is on it and can provide an update on.
The working group is Ali, Guzman, Poindexter, and Riley. So Carrie, you're the only one who's here.
I'm up. So my understanding is that we have been waiting on some feedback from Guzman, who I think we haven't seen in a little while. So I think that's where we're at with that. And then so we'll check in with the working group, and it's close. We finally got it into a better form that I think makes sense for understanding the analysis. And then we were going to have some, Mary had some really interesting, like, on point hypotheticals and topics that she was going to incorporate. So we will be ready to discuss the next meeting, promise.
When you say it's close, you mean there's close to having a draft to circulate for a meeting?
Yes, I think we should be able to get you guys a draft before the next meeting.
Okay.
Next one is 25-0001, attorney adjacent work and handling retainers and fees, Chivers, O'Reilly, Poindexter.
Chivers, O'Reilly, Poindexter. This, Cassidy, you want to touch on this?
There I am. Yeah, I think we just need to get started on an opinion. Although I did circulate an outline a while ago, but I can update it. Is this one? I see staff to draft opinion. Do you want me to update the update the outline for staff, Rachel? Is that one that we can?
Yes. This, I couldn't remember which one it was when I was talking earlier, and it was this one.
It was this one? Okay.
Once we get the finalized outline from the working group.
Okay, so if somebody could remind me next week, I will get you that outline. Well, you know what? No, like I'll let the working group take a look at it, and then we will get it to staff. How's that sound, working group? O'Reilly and Poindexter, Vakita and Dan.
Sounds great.
Okay.
Is that keeping with the process we just agreed to? Meaning, I thought the outlines were going to come before the committee as the next step, not go to somebody to start drafting something?
This one has been approved by the committee, I think, already, the outline. Yes?
Well, no. Well, I don't know. It's been around for a while. I mean, we could do that. That's fine to stick with this, but I like the idea of staff doing a draft opinion as well.
Let's try the new process and just see if we can get this outline in front of everyone for the next meeting, and then add anything, and we'll, again, the point is at the outline stage, you figure out whether it's going to be an opinion or an alert or some other thing. Add anything else, and it will be hopefully more robust for the staff to do it after that.
Yeah, that's a good idea. Okay.
Be the test of the new timeline.
Yes.
Okay.
And I believe that was it.
I have a quick question on this one. Is there any overlap there on that work and the analysis that's happening for the lawyer's expert? Do you think it would be helpful to have a conversation about that between the teams? I'm just curious because
because I honestly haven't looked at the outline, so it may be, so let's just put that on the agenda for the working group to talk about, and then that can be, I mean, could working groups talk to each other in the between meetings? You know, could we have a super working group? If there's over, no, Kathy's saying no, we cannot.
Because of Bagley Keene, we have to keep it under forum, so we cannot have two working groups meeting together to discuss.
Two lead drafters could do that.
Exactly, you could.
Yeah.
Drafters, but we just have to be careful that we are not creating serial meetings by two people speaking, and then they each speak to somebody else, and then all of a sudden everyone on the committee has the information. That is a violation. So you just have to be careful about how you are communicating and with who. And then staff can also assist with that. You know, if there are things that you would like us to take a look at or provide feedback on, we're happy to do that. We cannot be the go-between, but we can assist in the process.
Well, what we can do is have the working group finalize the outline, and then it will be part of the agenda materials, and there'll be a direction for the expert witness group to specifically pay attention to it, so they can comment on it at the next meeting.
Right. Yeah, the actual meeting. Novella.
Yeah, my role got skipped on the work plan for the arbitration reasonable accommodation working group.
Oh, I'm sorry. I thought that you had confirmed that you didn't need it on today's agenda.
Oh, no, I thought we were gonna put like a timeline in the row, which was just that we were gonna submit an outline for the December meeting. And then my question related to that is, what would be the date for the materials to be circulated so that they could be on the agenda? And I wondered if the agenda material we got today, where it has the meetings for the next year, if that can also add like the deadline to submit materials for those agendas, because I feel like those are the ones that sneak up on me, and would be good to know in advance.
That's a really great suggestion. Yes, we can incorporate those meeting agenda deadlines into that table and send it out to all of COPRAC.
Thanks.
And then, I'm sorry, I may have missed it. For the FIAR, what was the update for December?
An outline. Yeah.
Okay, right. So these two, the ones we just talked about, are on the new schedule, and we will see how that goes.
Oh, there it is.
Raquel looks skeptical.
I'm not skeptical. We have a process and we stick with it, we'll be fine.
Well, if not, we'll adjust it. That's the idea.
If we don't, we'll do the same.
You got that? Right.
And Eleanor has her hand up.
Eleanor.
Sorry, I just never brought it down. Apologies.
Okay.
Oh, she don't.
Okay. Does that bring our work plan to an updated state?
Yes, our 2025 work plan is updated.
Do we need to vote it out?
No.
Okay. Boom. Done with that. Okay, the next item is discussion of new ethics opinions, rules, and other requests, which I am presenting, but the goal is to discuss and vote on any received requests, conduct a review of the pending requests we haven't acted on yet. And there's a new request regarding 1.7, then we all received the list of pending requests. So let's turn to that, and we'll pull that up in a moment and go through that. This is where the opinions will be born, and from here they'll go into the timeline and see how it goes from there.
Is there a date for the ethics symposium already?
Yes.
It should be on the dates that were circulated, yeah.
Are you going to discuss the topics or is that?
Today, yeah.
I'm sorry, are we doing symposium topics or
No.
opinion topics right now?
Opinion topics.
Opinion topics. Yeah, where is it?
Yeah.
I have a question about the staff's role in this whole process, meaning when you get ideas from outside, emailed in, what is the process? Do they get a response back immediately, or sort of, if you could just remind us of the process?
Yeah, so staff keeps a running list of all requests for ethics opinions and requests for rule changes, and that is what is currently being displayed on the screen. And then once COPRAC decides to either act on it, hold it, pick it up and create an ethics opinion, then staff responds accordingly. So if COPRAC declines to issue an opinion, then a letter goes out to the requester indicating that. But otherwise, they are just held until they are acted upon.
Okay, so may I ask you a question? When it talks about the requestor and the date of the request, is there a reason why we don't get to know who that attorney was? Oh, it's just attorney or public? Is that what the difference is?
Do you know the answer to that? This one predates my involvement with this committee, so I'm not sure. Oh, it looks like it's just, it's classified by where it came from: public member, attorney, state bar staff, COPRAC.
And if a member of the public does take the time to make a request, is it acknowledged by staff and saying that it will be considered by COPRAC, or letter or something?
Yes, so we get requests through the mail, we get requests through email, and we will acknowledge that the request has been received, and then they get forwarded on to the entire committee. So an example of that is the request to amend 1.7. That was submitted via email and a letter, and that was sent out to the entire committee, and I believe should now be on this list in front of us.
Hi, I just really want to say a gentle reminder, please use your microphones so that the people online can hear as well and so that it's clear for the recording.
Pardon me. So September 15th, 2025, number 22 is the one that we're talking about, 1.7?
Yes.
Okay.
Yes, exactly.
Okay, let's just sort of think about an efficient way to work through this. I don't know that it's going through one of these one-on-one that we've already done multiple times, but maybe that is required. Is there a better way?
Didn't we all submit our preferences?
Yeah.
Was there any consensus or hopefully?
I want to be so hopeful.
We did not get a very high response rate, was part of the problem. But Karen, can you pull those up, and maybe that would be a good place to start, because we did have some that were requested by multiple members, so that might be a good place to start.
Okay.
Raquel.
I think in what we just approved, our processes, et cetera, there was a recommendation on how to handle this chart, presumably. Did I understand that correctly? Okay. So I think we should follow whatever we said, sort of. But I think we should dispose the things we're not going to work on.
Yeah.
Like this list goes back too far. And so I think it's not what we're going to just add, but like just get rid of some of this stuff. I'm really not feeling great about the silence that we're giving to people who are submitting things. I think that doesn't seem to be embracing of people, even if it was just a automatic reply. We got your we got your request. So I didn't know how it happened, but I think we should at least talk about. And then going forward, one of the things the process did say was every meeting, I think, we were going to consider these things, and I feel like that's too regular. Particularly if we have a work plan and the idea, as I understood it, what we lock in on is what we're gonna do. And unless it's Supreme Court or some timely issue like the group that worked on the domestic violence, I don't know exactly what the thing was called, we're gonna be very leery of adding things. So to me, quarterly seems more like a rhythm. Or every 4 months, or I'm using quarterly just because it's probably easier to keep track of. But I think in order to go from where we are to some other cadence, this list, we just gotta make some hard calls. Most of the stuff that's still here, the people who were even working on it or thinking about it have long been gone, and probably the topics are not helpful. They're not, like we've missed the window maybe. So I didn't submit new topics because I just feel like, one, we have a work plan. Two, it's hard to know with this list without disposing of these things. And I think maybe we've been a little unwilling maybe to say, we're not going to do this. But I think we need to, and it goes in line with our processes and being more effective.
All right, let's go through this list and just be brutally honest about what we're not going to do.
Did we lose our form?
Yeah, because did Vikita leave? She's not here, but.
Vikita left, but I think we should be okay still.
Okay.
Okay,
And
I
everybody
just wanted
else
to
is
make
still
sure
here.
if we were gonna,
Okay.
I just wanted to make sure if we were gonna be voting.
As long as Cassidy's still online, I can't see.
She's here.
Yeah.
Yeah, you're
And
still
Eleanor.
here.
Yeah, okay.
And Eleanor.
Oh, and Rebecca, yeah, we're fine.
And Cassidy's not voting.
Okay, I just wanted to make sure.
Okay. Okay, let's go through the list, and I would propose doing this efficiently, meaning if there isn't somebody who makes a specific pitch for one of these, then we are going to move forward.
Great.
Okay. Yes, Aaron.
My question is, I understand that initially they're acknowledged when someone asks, like an attorney outsider asks. And if they're on this holding pattern, is there ever a determination that COPRAC has declined to act and then they're notified? Or is it just always perpetually hold?
No, if and when COPRAC declines to act, which they have, then they get a letter letting them know.
Okay,
That was the result.
that's all I want to know. Thanks.
So if COPRAC decides today they are declining to act on some of these, then staff will send out letters to the requesters indicating that.
All right, let's go through this list, but I would also just like to say that if somebody as we go through it, the starting question will be, does somebody want to make a case for why we should take this up? Number 2. Hearing none, I would take that off. Number 6.
I will note that 7.2 attorney advertising issues, there were 3 members that indicated they would be interested in addressing this topic.
I think that's because, well, I'm not speaking for others, but I did feel forced to select 3 in that email. And so if I was one of those, I don't really want to do this. But I felt like I had to select 3 from the available topics.
Okay.
Just throwing that out there.
Just so you know.
Does anybody want to make a case that we should do 6? Hearing none, we remove that. Does anybody want to make a case that we should do number 9?
Well, what, it's rule 1.16, but what about it? That's the termination rule.
Yeah, didn't the ABA model rule get revised? And so is the question, although this seems old.
Karen's going to look it up. This is supposed to be linked here, but the links are not working.
Okay. We'll come back to that one.
Come back to 9. Number 10, updates to colleague impairment. What were the updates? I think the updates were going to be staff-driven and sort of minimal related to some citations. Does that make sense?
I'm not familiar with this
Yeah.
request.
I can speak to it.
We'll come back.
Yeah. This opinion was updated to talk about Rule 8.3 and to just update the lap services. So I believe that this one is completed. This is something that the committee accomplished, I believe, at the end of last year, but I could check the website to make sure.
That's a
Yeah,
W.
that sounds familiar. Yeah, that's a W.
Completed. Number 10 has been completed.
And then going back to number 9 and ABA model rule 1.16, it looks like there was a request to regarding clarification of a lawyer's responsibility to inquire into and assess the facts and circumstances of a matter before accepting a new recommendation and under some circumstances before continuing representation. I think there's a typo there. I think they mean representation. The inquiry is related to determine whether the lawyer's services would be used to commit a crime or fraud. And there were amendments made to model rule 1.16 reflecting this, and it looks like there was a request to have California adopt those as well.
I'll vote for that one.
Okay.
To stay.
To stay.
I'll look into it and then I can present it at the next meeting.
Right. That'll be the disposition if somebody says I would want to
Yeah.
do this in more detail.
I can present it and then the committee can vote on keeping it or not.
Yeah.
Okay.
Okay. 10 we completed. 14, anybody want to make a request to take this up in the way that we just described, meaning you'll look into it and report back to the next meeting?
I mean,
Didn't it go to something,
I can't see the
it
disposition.
says it went, well, it was referred to the client file release and retention working group?
yeah, we're still working on that opinion.
Okay, so that is actually under consideration as part of that opinion that's in progress then, yeah?
Oh, didn't we need a criminal defense attorney?
We did.
Hey, Adam.
we have one.
Sure.
Got a working group for you.
Okay.
We've just been waiting for Adam to show up.
I'm here.
Number 16. Anybody want to make a request that this one be put on our agenda for next month after they tell us why? Next month. Hearing none. So, who said that?
Was that you, Novella?
Yeah.
Okay. Novella will analyze and report. Thank you. Number 17, exemption to Rule 8.3. Anybody want to?
This has been, the rule is enacted and attorneys are already, this is already exempted.
Another win.
Look at us.
completing. Number 18.
Oh.
Okay, that's in progress. Okay. Number 21. Cassidy was going to make a recommendation. I don't know whether she has yet done that or not. You still want to do that, Cassidy? 21.
I was gonna make a at the, oh, okay. Well, look at that. Yeah, put that on the agenda for next time. I do think I remember we had this conversation about whether or not the ABA opinion is sufficient to, it would just be repetitive if we issued an opinion on this. So I'm happy to button this up one way or the other at the next meeting.
Right. Thank you. 22, proposed revision to 1.7. This was received just last month and circulated. Does anybody want to take this up for next meeting and advise?
The risk of overcommitting myself. I mean, that rule I have a lot of interest in.
Okay.
So
Yeah, that's your.
I'll take that.
Okay. Okay, and just so everyone knows, when your name is on there to report back, you can report back and say, like, I don't think we should do it for these reasons. I looked into it, or you can say, I want to take it up, in which case you'll move into the outline phase. Okay, 23. Guidance for fee arbitration involving provisionally licensed attorneys. Anybody want to take that up and analyze it for the next meeting? Do we have any arbitration people left on the COPRAC? I'm not sure we do. Yeah. All right, hearing none, I would say we would just remove that.
Do we still have provisionally licensed attorneys?
I mean, it's becoming such a tiny little subset.
There's a couple.
It's
yeah.
it's such a tiny subset of, provisionally licensed practitioners. It doesn't seem like it warrants a full opinion at this point.
Are you talking about like post-bar law clerks?
No, there was after the October 2020 bar exam, and then they changed the calibrations. They allowed for a cohort of provisionally licensed attorneys. And then after the more recent February problems, there were another group of folks that are going to be able to be provisionally licensed until I think only sunsetting next year now instead of this year.
What is the resolution of that? When they're provisionally licensed, how do they become fully licensed?
It's different pathways.
Okay.
It's not only one.
Okay. Declined. Number 24. Ethics alert on pro bono reporting. Clarification on what qualifies as pro bono hour. Does anybody want to analyze that and reply next month?
I'd be interested in looking into that. So
Okay.
are we getting like a to-do list after this, or should I just be,
You will be getting a to-do list. Yes.
Okay, I will look into that because I do think that's people ask me this question and it's not that clear.
Okay.
And this was specifically brought up by State Bar staff. I don't even remember who at this point. But because of the new reporting rules that are going to be going into effect, and what activities constitute pro bono, that's what it was. It was specifically in regards to fee arbitration. And do those hours that attorneys are volunteering as fee arb count? And then
They better.
broadened beyond that, so.
I can answer that question, but there's lots of other stuff that
Exactly.
absolutely, yes.
Is California getting a pro bono requirement?
Yes, it's going to through your State Bar profile.
Let me just clarify.
It's reporting.
You
Yes.
do not have a set number of hours that you must
so it's not like
complete,
New
but
York where you have
must
to do 50
report
hours or
if
whatever.
you did it or not, and how many hours if you did.
Oh, okay. It's a reporting requirement, not a performance requirement.
Right.
Got it.
Yeah, like in Illinois, where I'm also a member, they ask you questions designed to shame you into doing pro bono work. The first question is, have you done any? The second question is there any reason you can't, right? Yeah, so it might be something like that. Okay, Aaron will report back on the December meeting. And 111. Does anybody want to make a case to pick that up and report it?
Sure.
Adam will
Sure.
tell us next month what to consider. Okay, number 112, mediation confidentiality. Anybody want to take that up and recommend it? Hearing none, I'd say we remove that from the list. Number 113, lawyers soliciting favorable online reviews from clients.
I can look into that one.
Allison will report back in December on that one. Thank you. Number 100, gifts to indigent clients. Hearing none, I would suggest that we remove that. 101, office sharing with people not in the law firm and the ethical implications involved. I'll look at that. That could be an ethics alert. That is something that with remote work might be more relevant. O'Reilly.
I think there's already an opinion on that.
I think there is too. That was what went through my mind is I think there's enough on this already. But you could look at that, I suppose, and let us know. Yeah, if you
Well, no, that's why I chose it, obviously.
Okay.
Everybody says it's already been completed. No, if it's done, we're going to take it off the list. Let's take it off the list. Completed.
Because you know it's done, or no.
I'll confirm. 102. Can a departing attorney take their work product with them?
I can look into this one as well.
Okay, Allison.
I like that one. Yeah.
That does come up a lot in our practice. Yeah. What's in your brain versus like papers and whatnot. You can take your brain.
Everything else here.
104.
This is an interesting one too. Just the Mueller case on isn't that the privilege? Hold on. Yeah. I don't know. Let's see. I'm having a hard time reading this. This is all I'm going to. Okay, well, I don't know.
Anybody want to take this up and present next month? Hearing none is.
Should we just put that one as a revisit since we had one? Are these being removed permanently? I think some of them are, right?
Yes.
Given there was some support for that, maybe we just put this as a revisit next time.
Well, it's been on there since 2019.
Oh, has it?
Yes.
All right.
It seems like it's timed out.
Probably eternity doesn't
Since
care
this
anymore.
case law, since these cases were decided, I'm sure they've. sorted
Other
it out.
cases have been decided, interpreting it potentially, yeah, so.
We're a little late.
Okay. 106. Can you refer a client out to another lawyer without violating your duties if you're conflicted? This is from 2017.
Is there guidance on this?
Eleanor, want to do that?
No.
Okay. Just say we remove it. That was trailing from 2017.
You passed that.
109.
In progress.
Is 109 in progress?
What does that mean, Rachel? Accepted.
Well, that means that I guess back in 2022, COPRAC, or after 2022, COPRAC accepted it and was working on it, but I'm not familiar with what happened to this.
Don't worry, neither are we.
So why don't we make the disposition that we'll assess what happened, because it might have been the working group decided not to continue with it. That's one of the outcomes.
Yeah, we can look into this and figure out what happened.
Same for 19, it looks like the same status.
That one we're currently working on.
Okay, great.
Yeah.
Yeah.
In progress.
Right. Novella and Raquel. You're gonna get a draft outline in December.
Okay, and then these are ones that have already been declined. So anything we decline today, we will now move to the bottom of this table, and I believe we've now looked at everything we need to with this.
Okay, for those of us who are working on reports for December, the idea is like analyze the issue and determine whether you recommend that we do an opinion outline or move forward with an outline under the work plan, the process that we described. You can also give your opinion, and you should, about whether it should just be an ethics alert, because some of those look like they might be suitable for that. And that can be something that you include as part of your recommendation. But we'll go through the list of the ones from today that are on there and make a decision in December about what's going to happen next with them.
Since I'm new, can I just get a little bit of clarity on what the difference between the two are?
Yes, a full-blown ethics opinion is like the long-form written text with the issues presented and the sort of syllabus and the hypos included. Yeah.
Sorry, I meant like, what would be the difference in the consideration?
Oh, yes. The ethics alerts, something that is probably susceptible to, it might be a discrete question that is susceptible to 3 or 4 paragraphs addressing a particular issue that is more than likely not extremely nuanced. It's sort of a downshifted version of a full analysis. For something that might provide clarity about an existing rule or confirming a previous opinion position, as opposed to the types of things that we've been talking about in detail here, where we're trying to draw new lines and nuances and clarify, them in greater detail. So examples of ethics alerts that we have done in the past are, that was practical guidance, which, it was like an alert. So it wasn't a full-blown opinion because it was really just an application of the current rules to a new situation. So it wasn't analyzing something that is unclear. It was just applying and telling people how to apply. That's a good example of it.
The judicial threats was also a recent ethics alert that COPRAC put out.
Judicial
to deal
threats.
with the emergent issue and just
Right.
analyzing the law as it stood.
So if the law as it currently exists or the rules as they currently exist would apply and cover it, the ethics alert just sort of clarifies that and details that, instead of what the opinions are doing is sort of guiding people through areas where it might be an open question or very nuanced where the lines are. That's what I think of as the distinction between them.
Thank you.
And staff will email out the original request and any accompanying materials to the individuals who volunteered to take things up. So expect that from Karen.
Okay. The 2026 work plan, I think the recommendation from staff is that we put this on our December 5th meeting, in part because we're going to go through these new opinions and identify whether we're going to do something with them, and if so, what. So they would go on there, and the ones that we're going to move forward with are going to go into our new process with a working group and an outline.
Yes, and I will just highlight that the COPRAC 2026 work plan has to go to the Board of Trustees Executive Committee at their February meeting. So in order to get it on the agenda and meet our deadlines, in order to get it on the February meeting, we will have to vote on it and have it approved at the December 5th COPRAC meeting.
Okay, that brings us to the discussion of the 2026 Ethics Symposium topics, and we have a date, which is in the scheduled meeting dates, which I think is April 17th?
Yes.
2026. And we have we're going to discuss this and determine topics and then the next steps. Including putting together people who might take the lead on it, and if they're interested in doing it. As you go through and look in more detail at something that's been a topic, you might refine it. You might find that it's more important for other people to be involved and include them or something like that. But this is October, and it seems like April's a long time away, but as we know, it's not. Especially if we're looking to bring in people who are not on COPRAC. We want to give them as much time as we possibly can to be included in that, which I think is a really good thing to do, because when we've done it in the past, it gives a great perspective to the issues that we think of every month. Okay. So we're going to look through a list of proposed topics.
Yes, let me share that. And while I'm pulling that up, I just wanted to, from the staff perspective, I just wanted to give COPRAC some information. We have been getting a lot of requests, both on the ethics hotline and through Department of Regulation inquiry forms regarding immigration issues, specifically immigration and how to conform to their ethical responsibilities when that may not necessarily align with the current administration's immigration enforcement. We've also been receiving questions about First Amendment issues, searching phones, a lot of the type of stuff that you see in the headlines. So I just wanted to bring that to COPRAC's attention in case it was something that COPRAC was interested in working into the ethics symposium.
Yeah, the phone issue in particular is one that I think has come up a lot on listservs that we see with ethics issues related to somebody basically seizing your phone at the border and what they might see on that. Okay.
And I just note from the people that gave us their votes over email, we have 2 that are tied for first place with 4 members voting. And the topic was attorneys' ethical duties when the rule of law is under attack. And then the second one was ethics challenges in evolving law practice, AI, remote work technology. 4 members voted for both of those, and then 3 members voted for succession planning.
How many hours is your ethics symposium?
I believe it's 5 hours total. I'm going to double check the work plan because it's on there.
So the structure of it, just for new members, is that it includes a sort of a first period when there's sort of a recent updates and there's a focus to that usually, which is done by leadership. And then, so I think that would be me and Cassidy and maybe Eleanor as well. Updates, the year in review, and then there's usually several different items that are focus of particular discussion in that first hour. And then after that, there are 4 individual sessions which are led by somebody on the committee or 2, and then they frequently will bring in outside people to give their opinions, and it's all done by Zoom. So there's actually really pretty good attendance on that meeting, and the more senior people on the committee tend to take the lead on the symposium topics, but it's definitely available for everyone to participate. So let's start by just discussing the ones that people actually voted in favor of, because they're definitely timely and I'm interested in them. So we have the first one, which is kind of like the update, and that would include, things that I think would be sort of a generalized year in review type topics that were relevant, focusing on a few in particular. So that will be covered. And then, all right, so these are 3 that have been affirmatively sort of put out there. Attorneys' duties in light of the rule of law and challenges to that. Ethics in evolving AI and remote work, and succession planning, which I presume means in a law firm ownership. We have a succession planning opinion, which would obviously be the starting point, but I do a lot of this in my own practice, and I can tell you that it is very timely. So if people are interested in this, I can also help with materials and other questions that people have asked me and come ask me every single day. Okay, so I will just listen for a bit and hear if from this list, from the list of people that, the three that have been voted for, you know, people's reactions, and then also from this list, other ones that we should put up here and consider.
And this is a very long document. It's
Right.
5 pages. It was emailed out, so everybody should have access to it. What's displayed on the screen now is only the new topics that were suggested after the 2025 symposium. There are additional topics underneath that were suggested in prior years.
Raquel.
I did not submit, but I do have things to share, if now is the time. For the leadership dialogue, and I did go through this list and highlighted, and that's the basis primarily of what I would say. And or things that are topical. So I thought that the domestic violence, I don't know, was it an alert? What, for the group, what was that called?
The solicitation rule?
Yes.
There's
It's
a rule
rule.
revision.
So I think that seemed like there was some urgency about it, so it seemed like something to share in your leadership, because you all do some
Yes,
topics.
definitely.
I think the DA ethics alert, whatever we come out with that seems like there's enough lack of clarity that we should probably include that.
Right.
I said the conversion clause because it also seemed like there's some need to clarify in a large body. Maybe the advertising, but we took that off of our list, so, but I said that because there was advertising, seemed like it came up multiple times, multiple years, and we've not talked about it, so, but we just got rid of it. Some commentary probably around 25 bar exam, whatever happened, whatever the issue is, and the remediation around that for clarity, so people aren't hearing things through the grapevine, and then whatever the 26 process will be, and that's just more being proactive as a bar to say, let's just tell you something. So that's what I saw for that first group, for the morning, kind of some topics. I think it's probably too many for the time, but those are the range. And then one thing that seems consistent is people feel like they don't have their questions answered. And so one thought is to only have 3 sessions instead of having 4, so that people can have more time for questions, because I think we like to give information and we feel good about that, but I'm not sure people are feeling as good about not being able to answer questions. So that's a consideration. I'm saying that instead of reducing the session time, because it seems like the sessions, we run out of time, right? So
That was something that came up at the end of the last one, and let's just come back to that, because that was sort of a structural question. The idea was that for some of the sessions, we weren't specifically addressing their questions. So the idea was to have more time at the end for questions to come in through text.
Right,
Yeah.
okay. Then for the sessions, I think whatever we have at the time of the symposium around digital assets or crypto, we should have a session probably about that. I think the judicial topics, and I'm thinking maybe judicial meaning having judges there. People seem like they like that, and include sort of it be broader. So whether it's immigration, the rule of law, how do you deal with X, Y, and Z? So we would it would be being able to engage on that panel around a number of topics that the judges could share their ideas about. So not specific, but there seemed like there's enough topics that we could do that, maybe.
Judge panelist is also a good idea.
Yeah. The whole AI thing seems to be still on the list, but more like something that's hands-on. It seems like there's still a lot of people that are like, okay, that was interesting, but I'm still at step one.
Mm-hmm.
So some kind of AI hands-on workshop-y thing. I don't know how it would work, but I think what the feedback keeps saying is just what you're saying is interesting, but the members are not to that level yet. We kind of are at the tool level, maybe. So something like that. Maybe the idea of we had once which seemed popular, which was small practice topics, so succession planning, other topics maybe, because we do have a lot of smaller practice individual attorney members who attend.
Yeah.
So those are kind of the range, I think. I did have flat fee, because it seemed like in our group, the attorneys felt like this is important enough to share with the membership about this. So those are the thoughts I had. Over.
All right, thank you, Raquel. Eleanor.
In looking at these, it seems to me that we could potentially fold several bullets together. There's one that says ethics challenges in evolving law practice, technology, AI, remote work. I think a lot of what's in that artificial intelligence bullet could be folded in there, and then the outside counsel guideline bullet could probably be folded into one topic with, ethical challenges with technology, and that could also fold in some information governance type issues. But that seems like it has the potential for a session with a panel.
Right.
We also did outside counsel guidelines last time.
Specifically.
Yeah, I would see it as like a minor topic, a kind of a source of obligations.
Yeah.
Yeah.
You put that list up again? Yeah. I mean, so I one way to go about this would be to say, like Eleanor suggests, and I agree, is that we could put these into some categories and then have people refine them into something that would be presentable in the amount of time, with the right title and topic and focus, and then panel. So, I mean, there are what I would say like three categories here. The sort of rule of law, which I would include the immigration questions that are actively hitting a lot. Also, the impact of federal and state practice on executive orders, memos, administration changes, and the constant droning of details coming from federal government. We addressed the executive orders specifically last time, but I think there could be a panel developed where it's the rule of law, the immigration challenges, other government questions and lawyers' duties in that context. So that's one possibility. The other possibility is what Eleanor said with which people have voted for, ethics in evolving AI remote, where you would include the other ones that impact that and then come up with a focused presentation topic that would actually be achievable in the period of time that you might have. And then a third category might be, I would put like crypto in the AI remote evolving thing, because again, if it was very interesting, as you said, Raquel, that here the deep cuts of AI, but I think most of the members who are attending this are just like, what is it? Do I need to deal with it? Right? Which means it doesn't have to be starting from absolute square one, but it could be at least touched on a little bit of an orientation. And crypto is in the same category in my brain, theoretically. So there could be something that was accessible in a small practice setting for somebody who's like, should I accept crypto for payment of my fees? What is crypto? Bitcoin's apparently no longer a thing, so I don't know what happened there. I obviously would need the prime.
It's not the only thing.
Something else took its place. None of it sounds real to me, but that's just me.
Is heavily invested in it.
Okay.
Yes, it's a real thing.
All right, so that could be a third category, but putting that into maybe even small practice planning, sort of to Raquel's point, where you address some of these big issues from the perspective of a small firm or a solo. And a lot of the people who attend are in that category, and they're just like, do I even need to deal with AI? Can I just ignore it, right? Probably no anymore. Do I need to deal
Not
with
if you're
crypto?
using Microsoft. Because
Sorry?
I said not if you're using Microsoft, because it's
Well, Google,
or just about anything.
Adobe, Zoom.
Yeah, becomes
You,
ubiquitous.
you're dealing with it whether you know it or not.
Right.
So I would put some of those things, which would be kind of primers, into and more of an audience focus, which is solo and small firm people, so that some of that, including succession planning, could be addressed from the perspective of those. Okay, so that would just be putting combos together from the ones that people already identified and voted on, and suggesting that one of them is like more from an audience focus, like things that a small practitioner might want to hear about. And then other concepts, other ideas, something that's not on here that should be.
Well, I think I'd echo what Raquel said about the flat fees, but maybe expand that program into alternate business arrangements, not just, beyond the billable hour. So like what about value added? What about, modified contingency fee, hybrid agreements, flat fees, what's your duty to account, all of those things. Yeah. I think that would be really valuable, certainly to all practitioners would benefit from that.
Yeah, that's a good point.
Yeah, I agree with that.
Okay, the leadership block is the sort of year in review. Then there are 4 others, is that right?
I'm sorry, what's the question?
How many other blocks of presentations are there? How many other presentations are there in total?
Yes, so there's the leadership one, and then there are 4 1.25-hour sessions.
It's 90 minutes, right? 90 minutes?
An hour and 15. Totaling 5 hours total is the LE credit. Yeah, so each panel.
75 minutes.
Yes, is 75 minutes.
Okay. Other thoughts on topics or additions to some of these that we've identified that would be complementary to these? And the idea would be that the people involved would then refine it into something that, again, can be presented in about an hour's time, so that you have time at the end for questions and people feel like you're addressing the specific points that they're raising, because that was a feedback item that we got at the end of last time. And obviously, you can't do as much in an hour as, usually you think it seems like you would be able to do. And in other situations, an hour could be an extremely long period of time, depending on how it all goes. Okay, so what is the next best sort of process? Should we take this and have these things grouped? Because I can also help with that and then say, all right, now who is interested in these? And then the people who are interested in the grouped topics will basically define the program. Does that seem, how has it been done in the past?
I don't know, I was going to ask you.
Well, I propose we do it this way. Cassidy, what did you do last year?
Wait, so what's the question? How did we figure out, I'm trying to remember, what was the next step after this?
Right. How did you formulate the specific programs from the topics?
I don't remember. How did we
I propose that we
formulate?
sort of group them in the way that I described, and then have people on the committee identify the ones they might be interested in. And the goal would be that they refine it into a presentable topic.
Yeah, I think we just voted on them, and then there's leads, and then they broke out and planned their panels. That was basically it. But we can ask Erica. We can probably shoot an email to Erica and see if there's anything more involved.
Yeah, I mean, if we group them into sort of groups and people can say, I'm interested in this, and we'll just then say the assignment will be to develop a program with these topics, basically. And you would, part of that would be also to try to identify how to present it without it being completely overwhelming for 60 minutes.
I think you have a question.
Kathy?
Yes, I think that the suggestion to group them and then to come up with the people who want to lead them or who want to work on them is the way that we move forward. I'd also like to offer staff, if you need help structuring the programs to ensure that there's 60 minutes and that there's time left for questions. I know we did get a lot of feedback about that, and a lot of it can be adjusted with some forethought. So staff is happy to be involved with that. I've done lots of education, and so we are definitely available to assist with that as well as helping to, solicit panelists and collect all the biographies and photos so that we have a really professional and high quality face looking forward, I guess is. I lost my words there, but yeah.
Yeah, I know there was feedback about that as well from last time, so we will count on staff to sort of continue those threads forward. Okay, so is it, in timing, does it work that between now and December, we come up with the groups and put it out and say who's interested in these? And then in December, we just confirm the people and say, now go and refine this and present something with staff? Does that timing work?
Yeah, I think that that works. Staff can work to put them into groups based on the discussion today. We can email it out to everyone asking
Yeah.
who is interested in what, and we can go from there. Yeah.
That sounds good to me.
And I would also suggest that in the meantime, since we kind of have an idea of what the topics are, start to think about panelists that you would like to be part of this, because that can really help make things move much more smoothly. And then what we can do is we can just set up meetings to ensure that we're on track to present at the symposium.
Right, so what I think would be helpful is if you came to the December meeting, once the topics are grouped and sent with an idea of how you would approach that in terms of like hitting it and Kathy, do you think that 15 minutes like if we have an hour and 15 minutes for each session, the content is like 60 minutes and then the questions are 15. That's
Yeah.
right?
I would say that that's right, but the panelists need to respect their time that they're allotted, and the panelists need to be able to take the moderator's cues. And then it's really a decision about, do they want the questions during the panel? Because sometimes really relevant questions come up during the panel that if you wait till the end, they just don't feel as thought out or organic, I guess.
Yep.
And so those are things that staff can work with the panels with, just to ensure that everybody's on the same page and that we are really presenting a really high quality program. I mean, everybody looks forward to the ethics symposium. We have a lot of people that attend, and it's always been great. So I think this is just an opportunity for us to continue to improve it.
I think that's right. Where it worked well last year, the panel was actually taking questions in real time. And some of it was they were moderated, because a lot of the questions are, where are the materials? Which of course that can be answered in the text. But like Raquel, in your panel, the questions were coming in and then the panel was dealing with them because they related to the thing they were talking about, right? Then it was organic. But then I do think we should leave time at the end to come back and answer specifically questions that people raise. So that would be the structure of it. And that's going from comments that we received as feedback from last year, where people had, and I know that in my panel, we weren't really aware that questions were coming in until halfway through. And so we would be in a very different, approach, I think, at this point. And it does take a lot of effort to try to monitor questions as you're going. But a moderator approach where one person is doing that and also keeping the schedule and telling you're done to people. Because as Kathy said, if you're supposed to do 15 minutes and you do 30, everybody else is, way behind as well. And we can't address every single thing. So a lot of this work is going to be done in refining it down to very specific things that are digestible in 60 minutes, which is not as much as we might think generally.
I just wanted to add real quick that Rachel and I will be on there and we will be able to answer some of the questions and try to shepherd through which ones might be appropriate to answer. And having a moderator, I think, is really helpful as well. But I really want everybody to think about what they enjoy when they're viewing a panel. And usually it's not somebody talking at them for an hour. So I really want you to think about how you receive education as we're developing these panels. And I think that could really help us kind of fine tune things. And I know people are really excited to get out all the information they have in their head, but our participants can't receive all that information. So we need to just be mindful of that as well.
I think the other thing that really annoys everybody every time is if you don't touch on the stuff that you say you're going to touch on. You don't have to say that you're going to do it. But if you do say it, you have to at least touch on it, or it looks like you're just not giving them what they want. So it should be tighter, more questions. It's a little challenging because it's Zoom, and so you're talking, as a presenter, you're talking into a void. And the questions don't come from an audience, they come from text messages. But we know everybody's used to Zoom at this point, and so that's something you just anticipate. And with staff's help, I think it can be polished up so that people feel like, there's nothing people hate more, as Kathy is saying, than feeling like their question wasn't answered or you didn't get to their topic or whatever it is. So, okay, we have the next steps. If anybody has an inkling to take one of those combined categories and start thinking about it now, go for it.
Like I said, I think I can work with Raquel and we can work on fee structures. Because honestly, that's an hour.
Yeah, there's a lot there. A lot of it that's also related to.
If you have a good fee agreement, then you're not going to have huge AR. So that'll bring a lot of people.
Collecting fees is my favorite part of practicing law. So,
really? We
have
to talk.
It's my absolute favorite. That's all I really care about. Okay.
What was number 2 that you said?
Ethics in evolving AI, remote, and then like Eleanor put those together with
What was 3? I missed one of them.
It's like the small practice audience. That was your point, and that would include like succession planning, other things that would maybe fold into just the focus on that particular audience. Because that's another way to approach it, is not from a topic, but from a constituency, right? And I think we should do that if it's a majority part of our audience. Okay, anything else on the symposium? New business. Anything new that we haven't talked about? I can't imagine there's something we haven't talked about, but might be. Anybody? No? All right, thank you, everyone. We're adjourned.
Thank you. Have a good
Thank you.
weekend.
Thank you.
See your